that a second. All right, so I will be back shortly to give you the all clear. All right. Sorry for the delay. This round can go ahead and begin. Thank you for your patience.
Okay. All right, everyone, we've just received a message to get started. Let's call the case of the estates of Janice Petrello versus Peony Estates and Harper Martini. My name is Judge DeVlute. Scoring judge, please look to the two bottom buttons on the lower left of your screen and remember to keep your audio and video off unless you are told otherwise. You should have your video set to hide all non-video participants. That means that you can only see me and the advocates right now. Can all the attorneys please make your appearances?
Good afternoon, Your Honor. May we begin with appearances?
Please.
My name is Ruth Kim, and I am joined by my co-counsels, Daniel Chung.
Good evening, Your Honor.
And Chris Babineau.
Good evening, Your Honor.
Are here to represent the plaintiff in today's case, Joey Petrillo, as the administrator of the estate of Genesis Petrillo, pursuing the cause of action of civil battery.
Okay, defense.
My name is Hope Pattison, and I'm joined by my co-counsel.
Good afternoon, Your Honor. My name is Casey Simmons.
Good afternoon, Your Honor. My name is Victoria Cooper.
Okay, Victoria, we're getting a little bit of feedback on yours. Can you just try one more time just to make sure that there's nothing going
Yes,
on?
ma'am. Good evening, Your Honor. My name is Victoria Cooper.
Okay, perfect. Thank you. Is there anything that we need to take up before opening statements?
Yes, Your Honor. Before we begin, plaintiff has a couple of pretrial matters that we would like to address.
Okay.
First, we would like to invoke Rule 615, which constructively sequesters witnesses.
Absolutely, it's invoked.
May we assume that all witnesses have been sworn in prior to testimony pursuant to Rule 603?
Please.
What are Your Honor's preferences in regarding asking permission to share our screen for evidentiary purposes?
Do please ask, especially just since I want to make sure that everybody has a chance to object before it would be shown to the jury.
Yes, Your Honor. Your Honor, do we have permission to screen share rules of evidence, case law, stipulations, special instructions, and other documents regarding the case at hand as attorneys are arguing them?
Yes.
Are we free to move around during our examinations and our statements?
Sure.
May we assume that all evidentiary arguments are heard out of the earshot of the jury?
Yes.
May we assume that anything being screen shared is not published to the jury until it has been entered into evidence?
Yes.
And finally, we would like to remind the court that exhibits 1 through 10 are pre-admitted per stipulation 3.
Okay. Defense counsel, has any objection to that?
No objections.
Okay.
And with that, the plaintiff is ready to proceed, Your Honor.
Great. Defense, is there anything else that we need to take up before openings?
Yes, Your Honor. We believe you have access to a folder with all relevant case materials. Could you verify that?
Yes, I do.
Okay. And the defense would also like to bring your attention to stipulation 1, which stipulates that all exhibits of evidence are pre-numbered and pre-labeled. This means that exhibit 5 may be entered before exhibit 1 and vice versa. We would also like to bring your Honor's attention to stipulation 11, which states that the bottle of wine was found in the dumpster, and stipulation 17, which states that a canister of pesticides was found in this same dumpster. Also, at this time, we are designating the defendant Harper Martini as our party representative. As well, would Your Honor prefer whether we constructively approach the witnesses, opposing counsel, and the bench?
It will be constructive. Yes, absolutely.
Yes, Your Honor. Due to the and once an objection has been sustained, do we assume the testimony has been stricken, or should we ask to do so?
Please ask.
Yes, Your Honor. That's all of the pretrial matters the defense has.
Okay. Plaintiffs, did you have anything in response to those, or are we good to go?
We are good to go, Your Honor.
Great. All right, we will now hear opening statements from each party. Everyone should make sure they are in speaker view. That button is in the upper right of your screen. Attorneys, please make sure to remember to mute your audio when the other attorneys are speaking.
Your Honor, permission to proceed?
Please.
Your Honor, opposing counsel, members of the jury, may it please the court. Planned to poison Petrillo. Ladies and gentlemen of the jury, I want you to pay attention to those words throughout today's trial. Because throughout today's trial, you will hear evidence showing that the defendant planned to poison the victim, Genesis Petrillo. Now, this is Genesis Petrillo. He was about to be a married man. But on the morning of what was supposed to be the best day of his life, the morning when he was supposed to marry his soulmate, Mr. Petrillo tragically passed away. Now the question is, why did Mr. Petrillo die? Throughout today's trial, you will hear evidence showing that the defendant formulated a plan to poison Genesis Petrillo. For this reason, we are pursuing the cause of battery against Harper Martini, the defendant. Now, battery has 3 elements. And the 3 elements that we as the plaintiff have to prove are that 1, the defendant committed harmful or offensive contact towards the victim. 2, the defendant intended to cause that harmful or offensive contact towards the victim. And 3, we have to show that as a result of that harmful and offensive contact, the victim fell ill. Now, we have to prove these 3 things to you by a preponderance of the evidence. And in order to help you understand what that means, I want you to imagine the scales of justice. And on one side is the plaintiff's case, and the other is the defense's case. And throughout today's trial, both sides will be laying evidence on this scale. Now, what we as the plaintiff have to do is to prove our case by 50% and a grain of salt. If we tip the scales of evidence our way by just a grain of salt, then we have met our burden. Now, meeting this burden isn't necessarily going to be easy, but we as the plaintiff embrace it regardless because we know we can meet it. And we'll meet this burden by laying out the evidence and showing how the defendant planned to poison Petrillo. And we'll be doing this by calling 3 witnesses. First, you'll hear from the best friend of Mr. Petrillo, Angel Rodriguez. And this friend is going to testify to the contentious relationship between the defendant and the victim. And this friend is also going to testify to how the victim feared for his life when it came to the defendant. Secondly, you'll hear from a wedding caterer, Sam Arnold. This wedding caterer was part of the wedding of Mr. Petrillo. This caterer will talk to you once again about the toxic relationship between the defendant and the victim, and how the defendant formulated a plan to poison Petrillo. Finally, you'll hear from Dr. Kwan, the physician who treated Mr. Petrillo prior to his death. And Dr. Kwan, this doctor, is going to talk to you about what he saw when he was treating the victim. He's going to talk to you about how the victim died of pesticide poisoning, how this pesticide came from a wine bottle, how this wine bottle came from the defendant. At the conclusion of today's trial, my co-counsel, Mr. Babineau, is going to come up here today, and he's going to talk about the evidence. He's going to talk about the elements. He's going to talk about how the defendant planned to poison Petrillo. We expect at the end of today's trial, the only reasonable conclusion you'll be able to come to is that the defendant committed battery. We expect that you will find the defendant liable. Thank you.
May I proceed, Your Honor?
Please.
May it please the court. The bigger picture. That is what you need to focus on during today's case. The story that the plaintiff just brought to you is only a fraction of what actually happened leading up to the death of Genesis Petrillo. Their story was one of constant fights, destroyed relationships, and death at the hands of a disgruntled mother. The plaintiff cropped the photo of today's case. They left out vital pieces of information to fit their narrative. And I am here to tell you that that is an unfair depiction of this case. And together, today, we are going to zoom out and view the bigger picture. On June 7th, 2019, the friends and family of Casey Soto and Genesis Petrillo arrived for the rehearsal dinner of their wedding. It was being held at Peony Estates. The food was prepared, the tables were set, and everyone was looking forward to a beautiful weekend. But the guests didn't see what was going on behind the scenes. Peony Estates was struggling financially after the loss of substantial amount of the previous year's harvest. You're going to hear from Austin Lewis, the head winemaker, who will tell you about the persistent pest problem that led to the use of chemical pesticides in their vineyards. Due to similar infestations, the inside facilities were sprayed as well. Now, all of this was expensive, and any other substantial loss of revenue could lead to the end of Peony Estates. Now, Harper Martini was also dealing with a rival winery in Rapid River Valley, which led to consistent visits of an investigative reporter and a health inspector. Even though there were tensions between the owner of the rival winery, Danny Francasio, and Harper, Harper was so desperate to deal with her pest problem that she reached out on occasion for help. And with all of these consistent issues at the winery, her reputation as a winemaker was at stake. Now, in addition to all these struggles with Peony Estates, the relationship between Harper and Genesis was driving a wedge between a mother and her daughter. Now, Ms. Martini will tell you about her struggles to accept the fact that Casey was moving on. Like any single mother, she was protective of her child, and she made every decision with Casey in mind. So when Genesis came into the picture, she was apprehensive. But after seeing the way that Genesis loved Casey, she knew she needed to make amends. Now, even though this isn't the way Harper pictured Casey's future, Casey was happy, and that's all that mattered to Harper. Now, on the night of the rehearsal dinner, Harper decided to extend an olive branch in the form of a bottle of wine. This wasn't just any bottle of wine, but one specially crafted with Genesis in mind. Harper knew that Genesis liked higher-end wine, so that's what she decided to create for him. During the rehearsal dinner, Harper got up in front of all of their friends and family and accepted Genesis into the family while delivering this bottle. Now, the burden of proof does rely, in today's case, is up through a preponderance of the evidence. Now, the best way to illustrate this is the scales of justice. If the scales tip ever so slightly in favor of the defense, then you must not find the defendant liable. The plaintiff must prove to you through this burden that Harper Martini intentionally mixed pesticide into the bottle of Cara wine, and that Genesis drank that poison wine as intended, and as a result, Genesis Petrillo died on June 8th of 2019. Now, after the tragic death of Genesis Petrillo, Harper lost everything. Her reputation as a winemaker, the business that she put so much work into, and most importantly, she lost her only child. Why would Harper bring this on herself? When you look at the bigger picture and all the issues that Harper was struggling with, it shows you the flaw in the plaintiff's case. it just doesn't make sense. The motive isn't there. Focus on all the evidence, not just the cropped photo the plaintiff wants you to see. Find the bigger picture. And once you do, you must find the defendant not liable.
We ready to call our first witnesses?
Yes, Your Honor. Plaintiff calls Angel Rodriguez to the stand.
Okay, and before our first witness starts, I'll ask everyone to switch back to gallery view. You can go ahead.
All right. Introduce yourself to the court.
My name is Angel Rodriguez.
And Ms. Rodriguez, what do you do for a living?
I'm a kindergarten teacher down at our elementary school.
Ms. Rodriguez, why are you here?
I'm here to talk about Genesis, what was supposed to be his wedding and everything I saw that night.
Now, you mentioned a Genesis. Would you recognize a picture of Genesis Petrillo if I were to show it to you today in court?
I would.
Your Honor, permission to publish what's been pre-admitted as Exhibit 1.
You may.
Now, Ms. Rodriguez, who's that in the picture?
That's Genesis.
And Ms. Rodriguez, who is Genesis to you?
Genesis was just the most amazing person that I'd ever met. We actually ran into each other over the summer one year, and he just lit up the whole room. I mean, it was just amazing. And he was supposed to get married to Casey.
No, thank you. You can take this down. Now, who's Casey?
Casey was Genesis's fiance.
And can you tell us where the wedding was going to be held at?
Sure. So it was supposed to be held at this winery, Peony Estates. It was owned by Casey's mom.
And Ms. Rodriguez, what, if any, role did you have in this wedding planning?
Well, Genesis asked me to play a part, so of course I did everything I could. But once Casey's mom, Harper Martini, got more involved, there was so much conflict and drama. She just made a mess.
Now, Ms. Rodriguez, I'd like to move forward to June 7th, 2019. What, if anything, was supposed to happen on that day?
Well, we had a wedding rehearsal that day, and then everyone got together to have this dinner afterwards.
And what, if anything, happened that evening before the dinner?
Well, it was just like the wedding planning. Harper just looked like they wanted to pick a fight with Genesis again. They even told Genesis that they
speculation.
Response, Your Honor?
Please.
Under Rule 702, if we may screen share that right now. Okay, I'll go on. Under Rule 702, this is under the witness's rationally based perception. This is Ms. Rodriguez has testified to what she saw as to the way Harper Martini appeared to her. We're not asking her to delve into Harper Martini's mindset or any other person's mindset. She's simply saying what her observations were.
May I respond, Your Honor?
Briefly.
I believe that the Rule 702 has to do with the testimony of expert witnesses, but I do believe that opposing counsel was trying to get the witness to testify to whether or not Harper Martini wanted to fight Genesis Petrillo.
Response, Your Honor?
Yeah. But that's not what the question asked.
I was more talking about the statements that Angel Rodriguez just made.
Overruled. You may proceed.
Yes, Your Honor.
So, Ms. Rodriguez, I'll ask you the question again. What, if anything, happened that evening before the dinner started?
It was just like the wedding planning. Harper looked like they wanted to pick a fight with Genesis. They even said, leave and save this family the headache. Otherwise, I will make you disappear. And I just got so scared.
And what, if anything, happened after you had that interaction with the defendant?
Harper just grabbed Genesis by the arm and yanked him into the hallway, and I didn't know what was going to happen.
And Ms. Rodriguez, do you know what happened in that hallway?
Later, I asked Genesis about it, and he told me that he was afraid that Harper was going to kill him.
Objection, Your Honor, to hearsay.
Response, Your Honor?
Please.
The statement that was being elicited from Ms. Rodriguez is that she was afraid that Genesis, or that the defendant will kill him, I'm sorry. And if I may direct the court's attention to Rule 803.3, the fact that Genesis said he was afraid represents a then existing mental condition, that being of fear. We're not offering for its truth value.
May I respond, Your Honor?
Yes.
I'm objecting to the statement that Harper Martini was going to kill Genesis Petrillo. I do not believe that that is a part of the emotional state of Genesis at that time.
Response, Your Honor?
Briefly.
Your Honor, the fact that she was afraid qualifies the statement as a whole, as a then existing mental condition. She's simply explaining why she's afraid. And we don't want to leave the jury guessing as to why she was afraid. Or he was afraid, I'm sorry.
May I respond, Your Honor?
No. The objection is sustained.
Your Honor,
Yes,
motion
Your
to
Honor.
strike the testimony.
It is stricken.
Yes, Your Honor.
Now, Ms. Rodriguez, what if anything happened after you interacted with Mr. Petrillo in that hallway?
Later, I saw Harper Martini. They were walking towards the kitchen and holding this canister that said pesticides on it.
And what, if anything, did you do when you saw the defendant holding a canister that said pesticides?
Well, I went to go ask Harper what they were doing, and they said, it's for pests, like Genesis. And I wish I stopped her or something.
Now, let's talk about the dinner itself. What happened during that dinner?
Harper kept calling Genesis a problem child, and they were giving out these favors, wine bottles, but they made sure that Genesis got this different bottle of wine, and it was really weird. It was called Cara or something.
And would you recognize that Cara wine if I were to show it to you today in court?
I would.
Your Honor, permission to publish what's been pre-admitted as Exhibits 2A and 2B.
You may.
Ms. Rodriguez, what am I showing you here?
That's the bottle that Harper handed Genesis.
Has it been changed or modified in any way?
No, it looks the same.
Now, Ms. Rodriguez, what, if anything, happened after Genesis was given this bottle of Cara wine?
Well, Genesis drank some and offered it to us as well, and I sipped a little, but I spit it out because it just tasted wrong.
And Ms. Rodriguez, what if, you can take this down now. What, if anything, did you see with Genesis after he drank that wine?
It just looked like something was off. I mean, Genesis was slurring. They couldn't move right. They even told me that this isn't a kind of feeling that I felt before.
Objection, Your Honor, to hearsay.
Response, Your Honor?
Yes.
Again, this statement, this isn't a feeling that I felt before. That is, again, goes under Rule 803.3, a statement of the declarant's then existing physical condition. The fact that he knew what he was feeling like and he wasn't feeling as what he was feeling before. If I may add on to that, Your Honor, it also, we would like to add Rule 803.1. This was a present sense impression. Mr. Petrillo was describing his conditions as it was happening, as he was feeling them.
May I respond,
Overall.
Your Honor? Yes,
No.
Your Honor.
All right, now, Ms. Rodriguez, could you repeat to us what Mr. Petrillo told you?
He said, this isn't a feeling I felt before, which made me even more worried.
And what, if anything, happened after you had that interaction with Genesis?
Well, we were sitting down. I wanted to tell him goodbye, but he was just slumped over, and it was weird because I didn't smell any alcohol on his breath, so I tried to get him up to his room so he could get some sleep for tomorrow.
And what, if anything, happened when you got to his room?
That's when I started to panic. Genesis they were throwing up all over the place and sweating, and right before he passed out, the last words I ever heard from him was to call 911. So that's what I did, and I never left his side. I rode with him in the ambulance all the way to the hospital.
And what, if anything, happened when you got to the hospital?
doctors told me in the morning that Genesis was in a coma. That's when I realized that I should probably tell his fiance, Casey. I mean, she was the one that was supposed to be here. So I did the best I could, and I ran back to the winery, the Peony Estates.
Miss Rodriguez, what happened when you got to the Peony Estates?
When I was there, I ran into Harper again, and before I could even say anything, I mean, I don't know how she knew. She said, Genesis got poisoned? Oh no, we'll have to cancel the wedding. I went to go tell Casey after that.
And what, if anything, happened when you told Casey?
I mean, she looked beautiful. She was in the white dress and everything. Honestly, I thought I'd be the one wearing it, so it just broke my heart to have to tell her what happened to Genesis. We rushed back to the hospital after that.
And what, if anything, happened when you got back to the hospital?
We were too late. 5 minutes before we got there, Genesis passed away.
Now, Miss Rodriguez, one more question here. Would you be offended if someone gave you poisoned wine?
Of course I would. I don't know why you'd ever want to hurt anyone. I'll never forgive
Objection,
Harper.
Your Honor, relevance.
Response, Your Honor?
Please.
If I may direct the court's attention to Burdett v. Copenhagen, the first prong to prove civil battery is that we have to prove that there was offensive or harmful contact. This witness stating that her receiving poison wine would be offensive or harmful goes to prove that element, Your Honor.
May I respond, Your Honor?
Oh, yeah, go ahead.
Your Honor, I do not believe that this statement is going towards that at all. If whether or not it's offensive to Angel Rodriguez does not have any bearing on whether or not it was offensive to Genesis Petrillo. And if on a specific instance, someone may have given Angel Rodriguez wine, I don't see how that's relevant in today's case.
Response,
I agree.
Your Honor?
You may briefly respond.
The fact is that we're asking this witness if it is offensive contact to receive poisoned wine. I have never heard of anyone that's ever claimed that receiving poisoned wine is not offensive, and simply we're having this witness testify to that, so that's on the record, so that we can help meet that burden, help meet that element.
I think that if no one would ever think that receiving poisoned wine was not offensive, you don't need this witness to testify to that.
Yes, Your Honor.
So the objection is sustained.
Motion to strike, Your Honor.
It is stricken.
Now, Ms. Rodriguez, what, if anything, did you learn when you and Casey got to the hospital?
I learned that Genesis died from poisoned wine.
At this time, we passed the witness.
Objection, Your Honor. I apologize to hearsay.
Response, Your Honor?
What did she just say?
The witness just testified that she learned that Genesis Petrillo died of poisoned wine.
Okay. Yeah, you can respond.
Well, Your Honor, to the first part of that, the statement that Genesis died, it's not in question today whether or not Genesis Petrillo passed away. So the truth value of that statement is already known. Thus, that's not hearsay at this point. As to the other part of the statement that she died because of poison wine, we're using that to show the effect on the listener and what impact it had on Ms. Rodriguez.
May I respond, Your Honor?
Sure.
I do believe that they are offering this for the truth of the matter being that Genesis died of poisoned wine. I do believe that they're offering it to show that and not the effect that it would have on Angel Rodriguez.
Response again, Your Honor?
Briefly.
Also, Your Honor, this testimony that Genesis Petrillo died from poisoned wine is a statement reflected in Exhibit 7, which is the death certificate of Genesis Petrillo. And that objections have already been waived to that. That evidence has been pre-admitted. Thus, it's on the record and an in-court statement at this point.
But, okay. Has she testified to who told her this?
She testified that she learned it at the hospital.
Yeah. Unless you want to lay foundation for the fact that it was from somebody who actually put it in the death certificate, it's gonna the objection is going to be sustained.
Yes, Your Honor.
Motion to strike, Your Honor.
Unless plaintiff cannot lay the proper foundation.
Yes, Your
Yes,
Honor.
Your Honor. Now, Mr. Rodriguez, where or how did you learn about Genesis' death?
I spoke with the doctors and they gave me this death certificate, and that's what it said. That
At this
Genesis
time-
died from poisoned wine.
At this time, we pass the witness.
There we go. I thought I was unmuted. May I proceed with cross-examination, Your Honor?
Please.
Ms. Rodriguez, good afternoon. I just have a few questions about what happened on the day of the rehearsal dinner. So first, you stated earlier on direct examination that you saw Harper in the hallway with a canister of pesticides. Is that correct?
Yes, I did.
And you stated that it looked like she was headed toward the kitchen, right?
That's what I thought, yes.
But at this time, you did not see the bottle of Cara wine, right?
Not then, no.
And you did not see Harper pour this canister of pesticide in the wine at this time?
Not then, no.
You don't even know if this canister had pesticide in it at this point, correct?
I'm not sure.
Okay, so then I want to move on to the rehearsal dinner. Now, during the rehearsal dinner, you were seated at a table with Genesis Petrillo, right?
I was.
And Casey Soto was also at this table, right?
Yes, she was.
And at some point, Harper offered Genesis this bottle of Cara wine, right?
Yes, Genesis got it.
And you thought that Genesis took this gesture well, right?
Objection, Your Honor, calls for speculation.
May I respond, Your Honor?
Sure.
Your Honor, under Rule 701A, I'm asking the witness to testify to their rationally based perception based on their history and friendship with Genesis Petrillo and how they were perceiving the situation as it was happening.
Response, Your Honor?
Yes.
But still, in order for this witness to know whether Genesis Petrillo was accepting this gift well or not, she would have to be a mind reader. She would have to know what was in the mindset of Genesis Petrillo. If anything, if this testimony is allowed, we ask for a limiting instruction that might not be specifically what Genesis Petrillo wanted, but only solely what this witness might have thought she wanted or he wanted.
I think that the question specifically asks that. And so if the jury takes it any other way, that's based on the jury's perception of the testimony, not based on what the question is actually asking. So the objection is overruled.
Yes, Your Honor.
Yes, Your Honor. Would you like me to repeat the question?
Yes, please.
And you thought that Genesis took this gift well, correct?
I thought maybe. I don't know what he thought, but I just wanted him to be happy.
But to you, you thought that Genesis took it well, correct?
Yeah, I tried to be positive.
So after the bottle of wine was gifted to Genesis, Genesis offered it to everyone at the table, right?
Yes, he did.
And that included Harper's own daughter, Casey Soto, correct?
I mean, she was sitting there, so I guess.
So that's a yes to my question. She offered it to him as well.
He did, yes.
Okay. And this was right after the toast that Harper gave, right?
Harper said that this gift was specially for Genesis and that Genesis should drink it alone. Yeah, that's what she said.
Ms. Rodriguez, I'm going to redirect you back to my question. Genesis offered this wine right after Harper made her toast, correct?
Yes.
And at this point, when Genesis offered it to everyone, Harper didn't stop Genesis from offering it to anyone, right?
I wasn't paying attention to Harper. I'm not sure, but yes.
So to your knowledge, Harper never tried to stop Genesis from offering the wine to other people, right?
I don't think she did.
Now, during this time, you actually had a sip of this Cara wine, didn't you?
Oh, it was gross. It tasted wrong, but yeah.
And Harper didn't stop you from sipping it, right?
I don't think she was around me.
So after drinking it, you experienced no vomiting,
Your Honor,
correct?
mischaracterization of the evidence. Opposing counsel just said that Ms. Rodriguez drank some of the wine. That testimony has not been established through this witness. She said that she sipped it, if anything, and as we established on direct examination, as soon as she spat it back out, or sipped it, she spat it back out. I'm sorry.
May I respond, Your Honor?
No, overruled.
Yes, Your
Yes,
Honor.
Your Honor.
So after you drank this wine, you experienced no vomiting, correct?
Well, I just spit it out, so I don't think anything would have happened to me.
So that's a yes to my question. You experienced no vomiting, correct?
No.
No convulsions, right?
Yeah, no, I didn't have those.
No sweating, right?
No, I don't think so.
To your knowledge, you didn't experience any symptoms of poisoning at all, did you?
Objection, Your Honor, calls for an improper opinion. This witness is not an expert in toxicology. She wouldn't know what the symptoms of pesticide poisoning would be.
May I respond, Your Honor?
Yes.
I asked on the basis within her knowledge and I'm asking her to draw on her knowledge of how Genesis reacted when he was poisoned. So I'm asking her to go based on just her knowledge, not any expert testimony at all.
Response, Your Honor?
Sure.
If the question were tailored to ask if Ms. Rodriguez got sick, then that would be understandable. However, she's asking us specifically the symptoms of pesticide poisoning. If Ms. Rodriguez experienced any of those, and as she's not a doctor, she wouldn't know what those were.
Any further response?
Yes, Your Honor. I do believe that she has witnessed several different symptoms by being with Genesis at all times of that night. If she experienced any of the same symptoms, then she can testify to that.
Response, Your Honor, on those?
No. If you can tailor your question to ask about that specifically, then that is fine. Otherwise, the question that you previously asked has been sustained and stricken from the record.
Yes, Your Honor. Now, that night, you did not experience any of the same symptoms that you saw Genesis experience, correct?
I wish I did, and maybe I would be with him instead, but I didn't.
Your Honor, I have no further questions at this time.
Any redirect?
Yes, Your Honor, one question. Ms. Rodriguez, on cross-examination, they asked you about drinking that car wine. Did you swallow that wine?
No, something was clearly wrong with it, so I just spit it out.
Your Honor, pass the witness. We have no further questions.
May this witness be excused, counsel?
No
Yes.
recross, Your Honor.
Great. Plaintiff, you may call your next witness.
Yes, Your Honor. Plaintiff calls Sam Arnold to the stand.
Hello. Hi.
Sam, we can't see you yet.
Oh, sorry. I am not good with computers.
No problem.
Alrighty. What are we doing today?
Your Honor, now that we've fixed the technical problem, may we proceed?
Defense counsel that is handling this witness. Okay, there we go. I'm ready now.
Could you please state your name for the court?
Well, my name is Sam Arnold.
What do you do for a living?
As you can see, I'm a chef. I just got off of work, actually. I'm a food service provider for the city of Midlands.
What is your relation to this case specifically?
If it concerns Harper Martini, it must be because I was the food service provider for the wedding rehearsal and the wedding, the day of the wedding.
Mr. Arnold, how did you get to know the defendant?
Harper Martini. So we met in 2016. We were both celebrating our first year anniversary. So she went with me to cater her event, and that's when we built our relationship.
How long have you been working with the defendant?
Well, up until the day of the wedding rehearsal dinner. So from 2016 to 2019.
Mr. Arnold, do you happen to know Genesis Petrillo?
I do. My first impression was when Harper, during our first meeting, would just talk excessively about her. She said many things, but what I've got from her was they had this negative relationship. She slammed a bowl on the counter, and I heard her yelling that anyone but Genesis, literally anyone. And after that, I kind of had a sense of who Genesis was because that stuck with me. And Genesis and I met a few times during our tastings. So I also met her in person, or him in person, I'm sorry.
Mr. Arnold, you mentioned before that you were part of the wedding rehearsal. How did that day start out for you?
Well, that was June 7th. Oh yeah, that was the night after I had a big party and event at a big Las Vegas venue. Okay, yeah. So we got there around 11 a.m. and I realized the kitchen was so disorganized, and it was during their lunch service, and I was able to ascertain that Harper wanted the kitchen staff to give her space so she could finalize gifts for the wedding guests that night.
What, if anything else, did you see when you were in the kitchen?
When I was in the kitchen, Harper told me that she pulled me aside and she's like, "Here, I want you to bring out these bottles to the guests tonight." So she told me about the 2017 Horizons. And then I noticed a unique bottle labeled the Cara bottle. And she told me this was something special for Genesis.
Would you recognize a photo of the bottle and the label if I showed it to you?
Yes, I would.
Your Honor, permission to display. Yes, Your Honor. What am I showing you?
That's the bottle of Cara.
And what am I showing you here?
And that's the label.
Now, taking down the exhibit, Mr. Arnold, what happened after you took, to your knowledge, what did you learn about this wine bottle?
Well, I learned that it was only for Genesis and that it was something special and it would solve Harper's problems forever. After that, I left the kitchen and from when I exited the kitchen, I saw this canister of pesticide, which was very strange. So I asked Harper, why she had it there.
What did you learn?
She said it was to kill pests like Genesis.
Mr. Arnold, redirecting you back to that wine bottle, to your knowledge, was anyone else supposed
Your Honor, under 403, I believe that they're using these statements for character evidence and they have no intention to use character. They did not submit character evidence before. Under Rule 403.
Response, Your Honor?
Please.
Your Honor, we are not trying to show conformity therewith. We're simply trying to show a specific plan on that day that the defendant intended the wine bottle to only go towards the victim, Your Honor. And so we're not trying to show conformity therewith in regards to past events, Your Honor.
Response, Your Honor.
Very quickly.
Response on the grounds of character evidence, I do believe that they are trying to establish a character trait of Harper Martini. And further, I would also like to raise an objection to more prejudicial than probative. These statements are substantially more prejudicial than probative in today's case.
Do you have a response to the more prejudicial than probative objection?
Yes, Your Honor. Your Honor, the specific piece of evidence that we're bringing is not more prejudicial than probative. It has to be substantially more prejudicial than probative, Your Honor. Your Honor, this piece of evidence has significant probative value, establishing that the defendant intended the bottle of wine to go specifically towards the victim, Genesis Petrillo. Has more probative value than it does prejudicial value, Your Honor. Also, am I allowed to respond once again to the 403 objection, Your Honor?
No. Your objections are overruled, defense counsel.
Yes, Your Honor.
Mr. Arnold, to your knowledge, was anyone else supposed to receive the Cara bottle?
Nope, it was very clear for me. That was the plan, to give it to Genesis as Harper was going to give her speech that night.
So, Mr. Arnold, what happened after you left the kitchen?
Well, after we had that talk about pesticides, it was around time to bring the bottles out when Casey was giving his toast. And many others followed that. And after that was Harper's speech. And that was my cue to bring out Horizons for all the guests and the Cara, especially to Genesis.
Mr. Arnold, to your knowledge, did anyone else receive the Cara bottle?
Nope, it was only Genesis.
So what happened after that?
Well, I packed up and left around 10, and I didn't return until tomorrow. Or I didn't even return. I tried to.
Let's talk about the wedding day in particular. How did that day start out for you?
So I was on my way to work. I thought everything was normal. And then I got a call from Blair who told me that Genesis.
Objection, Your Honor, as to hearsay, as to Blair's out-of-court statements that the witness is about to go into.
Any response?
Your Honor, the specific statements that were about to be elicited were specifically an excited utterance, Your Honor. If I may proffer, the statements that were elicited will go towards the revelation that Genesis Petrillo had passed away or had been was sent to the hospital, and so this was an excited event, Your Honor, and the declarant was speaking as an excited utterance. And so under Rule 8032, this is an exception to hearsay.
Response, Your Honor.
Please.
I do believe that this is still hearsay because they are out of court statements made by Blair, and with a conversation, there was no excited utterance in this. They were having a conversation, and this happened after the fact.
May I respond, Your Honor?
And can you show that this was actually an excited utterance?
Yes, Your Honor. The witness was specifically going to go into the particular statement he heard from Blair Osborne, and the statement was that the Genesis had fallen sick.
Okay, I understand what the statement is. I'm asking you if you can show me, before I let this be heard by the jury, whether or not this was an excited utterance.
Yes, Your Honor. The witness was going to go into how Blair was particularly excited during the moment, Your Honor. It was a stunning event when Genesis fell ill.
Response, Your Honor.
Hold on. I think you're going to have to lay some foundation for the timing of the utterance to show me that it was excited prior to it being able to be admitted to the jury.
Yes, Your Honor. Mr. Arnold, what, if anything, did you learn when you came into work that day?
Well, as I got a call from Blair, he sounded very concerned. He just told me that the day was going to be canceled because Genesis had passed the night before, or she passed and she got sick the night before. So
Objection, Your Honor. As to hearsay, these statements are clearly not happening while Genesis was dying. It's substantially after the fact, and therefore it cannot be an excited utterance.
I agree. Your objection is sustained.
Permission to strike, Your Honor.
Granted.
Mr. Arnold, to your knowledge, what happened on the wedding day?
Well, the day was canceled because Genesis had passed. And at first I considered if it was something to do with me because, I served the food to everybody. But luckily, to my knowledge, no one else got sick from the food that was served.
No further questions, Your Honor.
Permission to proceed with cross, Your Honor.
Please.
Now, Mr. Arnold, you mentioned that you were often at Peonia Estates. Isn't that correct?
Yes, I was.
And throughout your duration of working or catering with Harper, you often cooked in their kitchen, didn't you?
Well, to be fair, I actually like to prepare my food at home or at my own facilities because Harper's place was very disorganized.
Right. It was very disorganized and often chaotic.
Especially the day of the wedding rehearsal. Yep.
And you would agree that this is reflective of your kitchen's training, wouldn't you?
My kitchen? No, my kitchen is especially trained. What do you mean by that?
Let me rephrase. You would agree that the way a business prepares and handles its kitchen is reflective of their training, wouldn't you?
You have a point, but their personal lives also.
Objection, Your Honor, to relevance.
Response, Your Honor.
Sure.
The bar for relevance is extremely low in Midlands, and most facts of this case are very relevant, including going into his relationship with Harper Martini, the defendant today, and his work relationship with them and how she handled her kitchen, where the wedding was that day, on this day in question specifically.
Response, Your Honor.
Yes.
Your Honor, the bar for relevance in Midlands is low. However, there is still a bar that has to be crossed, Your Honor. These specific questions going into the practices of the kitchen staff at Harper Martini's estate is simply not going to make any fact more or less probable. This has nothing to go with any of the three elements of battery, Your Honor.
Response, Your Honor.
Yes.
We are trying to get to the fact that we are allowed to use other circumstantial evidence as stipulated in the pretrial matters by the judge, and the circumstances matter to prove that this might not have been the exact bottle of Cara wine. There are other possible causes of death, and we are able to assert these other circumstances, especially on cross-examination.
Objections overruled. You may keep going.
Now, let me return back to my question, Mr. Arnold. You would agree that the way a business prepares its kitchen is reflective of their training.
Yeah, that sounds plausible, yes.
And this is why you didn't like preparing food at Peony Estates, right?
Yes, I found it safer for food safety wise to prepare it myself.
And in regards to safety, you actually saw Harper with pesticides before, didn't you?
Yes, I believe I was coming to the estates and she had a backpack with pesticides. Yeah.
The pesticide sprayer, right?
Right, correct.
And in fact, she took this pesticide sprayer into the kitchen, didn't she?
I believe she just tossed it and I told her it was no place for a kitchen and then she moved it to the employee section.
Right, she took the pesticide sprayer and tossed it across the kitchen, right?
I think she moved it to the employee section where the bottling area is.
Let me redirect you to my question. You just testified that she tossed the pesticide sprayer across the kitchen, did you not?
Okay, tossed might be dramatic. Maybe she just moved it. I don't know.
So you wouldn't say that she tossed it across the kitchen?
Sure, she moved it from the kitchen. Yes, let's go with that.
Is it your statement today in court that you were testifying that you did not see Harper Martini toss the pesticide sprayer across the kitchen?
This is my first time in court. I don't understand. Am I saying something wrong? I disagree with you. She did move the pesticides. Yes.
You wrote an affidavit before coming to court today, did you?
Yes, I did.
And would you recognize a copy of this affidavit?
Yes, please. Yes, I would.
Judge, point of order, do I need to allow him access to his affidavit via screen share, or may I just read the line that I'm referring to?
Does he have access to it otherwise?
May I ask him?
Yeah.
Okay.
Oh, wait,
all right,
something.
Mr. Arnold, does this seem to be a fair and accurate copy?
Can you scroll down? I need to see my signature, just in case. Oh, yep, that's my signature.
All right, and does it appear to be changed and altered in any way?
This looks good to me. It's a lot of writing, though.
All righty, now I'm going to be talking about line 64 specifically. If you could just read in your head and I'll read it out loud. I saw Harper just toss the pesticide sprayer into the corner of the kitchen. So let me ask you again, Mr. Arnold.
Objection, Your Honor. To hearsay by improper impeachment, Your Honor.
Tell me how it was improper impeachment.
Your Honor, the witness already stated that the sprayer had been moved across the kitchen. It's not a clear contradiction by saying that because he didn't state the specific words toss, that he was inherently incorrect in what he saw, Your Honor. By stating that it had been moved across the kitchen, it is still not necessarily a clear contradiction, Your Honor.
Response, Your Honor?
No. I think that the fact that he would not agree with her when she said the word toss multiple times in the question was a direct contradiction, plaintiff's counsel. So we're going to allow the impeachment and overrule your objection.
Yes, Your Honor. So, Mr. Arnold, let me bring you back to my question. Did you see Harper Martini toss the pesticide sprayer across the kitchen?
Yes, I am so sorry. My English is not the best. I thought move and toss the same thing. You're right, it's tossed.
That's no problem. And just to clarify, this is the same kitchen that you prepared food in for your events at Peony Estates, right?
Well, I normally prepare them not at Peony Estates, if I just made that clear to you earlier.
But you did prepare food in this kitchen for the rehearsal dinner, did you not?
Okay, yes, for that one.
No further questions at this time, Your Honor.
Any redirect?
No, Your Honor, we just asked that the witness be allowed to step down.
Witness, you are excused. Plaintiff's counsel, you may call your third witness.
Good afternoon, Your Honor. The plaintiff would like to call Dr. Jimin Kwon to the stand.
Great. Defense counsel, okay, awesome. You're ready to go.
Please introduce yourself to the court.
My name is Dr. Jimin Kwon.
And what do you do, Dr. Kwon?
Well, I'm the chief emergency physician over at the River Valley Hospital in the Midlands.
Why are you here in court today?
I'm here today because I happen to be the treating physician for Genesis the morning of his death. Excuse me.
Now, doctor, what education do you have?
I first got my medical degree at UNC Chapel Hill, and I then did my residency over at Emory's Department of Emergency Medicine, and I stayed there to complete a fellowship in medical toxicology in particular.
Now, doctor, what relevant medical experience do you have?
So I myself, I've been an ER physician since all the way back since 2003. Although I treat all sorts of patients, I do specialize in toxicology. So when suspected poisoning cases ranging all the way from alcohol to homicide are admitted, I'm usually assigned those cases. And matter of fact, I have to actually go right back to the ER after trial today.
Doctor, what is your conduct like at work?
When I became a doctor, I took the Hippocratic Oath, and the two most important elements of being ethical is to, one, protect the patient's privacy, and two, to treat the sick to the best of my ability. Now, things in the ER can get really hard sometimes, but I ensure that I'm always honest and ethical with each and every one of my patients.
Now, moving on to today's case, what information did you have?
I first encountered Mr. Petrillo in the emergency room in the early morning hours, and I was able to directly observe his symptoms, and I completed a full medical examination.
Now, doctor, all these materials, were they sufficient for you to come to your conclusion?
Yes, so this information, along with the further tests that I ran, was sufficient for my medical analyses.
Doctor, moving along, your method, what method did you use to examine the victim in today's case?
So I follow the STAR method. Now, S stands for symptoms, T stands for tests, A stands for assessments, and then R stands for reassessments.
Doctor, is this method reliable?
Oh, yes, definitely it is. It's something that I used to always teach all of my first-year students at medical school. And if I recall, the error rate for this method is extremely low.
Did you reliably apply this method in today's case?
Most certainly I did, yes. The same way that I always do when treating all of my patients.
Doctor, let's move on to your method, the S part of your method, the symptoms. What symptoms did you see?
When Mr. Petrillo was first admitted into the hospital, I noticed he was exhibiting symptoms such as he was vomiting everywhere, his speech was slurred, and he wasn't even able to walk.
Now, doctor, moving on to the T part of your method, the tests. What tests did you perform?
So I did the standard blood test just to check for the patient's BAC, or blood alcohol content. Additionally, I also ordered a toxins analysis just as a precaution.
Doctor, moving on to the A part of your method, the assessment. What did you assess?
Well, initially, I did conclude it was alcohol poisoning.
Now, doctor, earlier you mentioned a copy, or you mentioned the toxins analysis. Would you recognize a copy of that analysis?
Oh, yes, I would.
Your Honor, permission to screen share what has been previously marked and pre-admitted into evidence as Exhibit 6.
You may.
Doctor, what am I showing you?
This looks like the toxins report to me.
Is it a fair and accurate copy?
Yes.
Has it been changed or altered in any way?
No.
Now, doctor, what, if anything, stands out to you about this toxins analysis?
Well, there's one thing that really stands out, and that's the presence of isofenphos in the patient's stomach contents.
Now, doctor, you mentioned that you initially assumed it was alcohol poisoning. What do you mean by initially?
Well, upon further examination, the patient was showing symptoms that were quite odd, like muscle twitching, contracted pupils, even excessive tearing of the eyes. And furthermore, the patient had a slowed heartbeat.
Doctor, now let's move on to the R part of your method, the reassessment. What can you tell us about your reassessment?
Well, these new symptoms that I observed were not congruent with alcohol poisoning. And so I suspected that the patient may have ingested something toxic, particularly an isofenfos organophosphate.
Doctor, could you tell the jury what an isofenfos organophosphate is?
Of course, now these are pesticides that are commonly used to kill bugs, and they're pretty frequently used over here in Midlands.
Now, doctor, how can the patient come into contact with pesticides?
Well, there are multiple ways to come into contact with pesticides, but I narrowed it down to just one. And I concluded that the patient had ingested pesticides and it had to have been through either contaminated food or a drink.
Now, what, if anything, did you conclude about the contaminated food or drink?
Well, we tested the patient's stomach contents, and we found two things. We found wine and we found food. The food tested negative for pesticides. However, the wine tested positive.
Doctor, what, if anything, helped you confirm your conclusion?
Well, there was also an additional test on the wine bottle, and that wine bottle also did test positive for pesticides.
Would you recognize a copy of the analysis of that wine bottle?
Oh, yes.
Your Honor, permission to screen share Exhibit 10.
Is this one of the pre-admitted exhibits?
Yes, it is pre-admitted under Stipulation 3, Your Honor.
Then yes.
Doctor, what am I showing you?
That looks like that's the wine bottle test report.
Is it a fair and accurate copy?
I would say so, yeah.
Has it been changed or altered in any way?
No.
Doctor, can you elaborate on this test of the wine bottle?
Of course. So I found out that the police had found and taken a sample from inside of a bottle of Caro wine that the patient drank from. And a laboratory analyses showed that there was pesticides inside of the wine bottle.
Now, doctor, what did you ultimately conclude?
I can say to a reasonable degree of scientific certainty that Mr. Petrillo ingested wine that was contaminated with an organophosphate pesticide, and that this contaminated wine gave her pesticide poisoning, which caused her respiratory system to fail, and ultimately resulting in his death.
Thank you. No further questions. We pass the witness.
Your Honor, may I begin with cross-examination?
Please.
Dr. Kwan, so you are the chief emergency physician at River Valley Hospital?
Yes, that is correct.
And you have a specialty in toxicology, right?
Yes, that's true.
And so you are the one who is given suspected poisoning cases, correct?
That is correct.
And you were given Genesis Petrillo's poisoning case, right?
Yes, because Genesis was showing some signs of some sort of poisoning. We didn't know at the time.
Right, so then you ordered a poisons and toxins analysis?
As a precaution, yes, just like we do for our other patients that are in for some poisoning related issues. That's correct.
Yes, and this analysis showed very low levels of an enzyme. That's right?
I believe acetylcholinesterase, if I recall correctly, right?
Yes, correct. And this was the method that you used to determine pesticide presence in Genesis Petrillo. Is that correct?
As an indicator, yes.
But this method does not actually test for a certain amount of pesticide, does it?
In regards to a quantitative value, no. We just can tell if it's a yes or no.
In fact, this method doesn't even test for the presence of pesticides, does it?
Do you mean in particular testing the acetylcholinesterase or the blood test?
Low enzyme levels do not test for the presence of pesticides, correct?
Yeah, so while there is no definitive answer, it's simply just an indicator.
All right. Now I'd like to talk a little bit about the toxicity of pesticides. So even the smallest dose, you would say, trace amounts, is enough to be considered deadly, right?
Yes, in relatively small doses, yeah.
And you're familiar with the affidavit of Angel Rodriguez, correct?
I believe that was a friend that attended the wedding too, right?
Yes. And Angel accepted a glass of this Cara wine from Genesis, right?
If I recall correctly, that is correct, yes.
And she took a sip of this wine, is that right?
Yeah, I recall him saying that he took a sip, but he immediately spit it back out.
But it was in her mouth long enough for her to taste it, right?
Objection, Your Honor. Speculation. May I be heard?
Sure.
Your Honor, the witness in turn does not have enough knowledge, enough personal knowledge to be able to speculate whether or not it was in her mouth long enough to do any sort of thing. Therefore, it is still speculation.
May I respond, Your
Honor? Hold on. Long enough to do any sort of thing? I don't understand.
Your Honor, the opposing counsel has asked the question of whether or not the wine was in Angel Rodriguez's mouth long enough for her to taste it. That is not in the scope of Dr. Kwan, because he does not know the mindset of Angel Rodriguez. He does not know what she did or did not taste. He does not know how long she had it in her mouth. Therefore, that is still speculation, Your Honor.
Okay, I mean, I think that if it's outside of his knowledge base, he can testify that it's outside of his knowledge base, and she can ask some questions about that. But I don't think that that is speculation based on the fact that he is aware of the incident.
Yes, Your Honor.
And this was in Angel's mouth long enough for her to taste it. Is that right?
I'm not sure exactly what it tasted like, but I think I do recall her saying that it tasted odd or something.
Okay, so it came into contact with her mouth. And you would say contact with pesticide in any form is dangerous, right?
To an extent, yes.
Which means it's likely that she could have ingested trace amounts, right?
By trace amounts, you mean very minimal?
Yes, even a small dose, right?
I'd say that's within the scope, yes.
And if this wine did in fact contain pesticides, you would expect to see almost immediate symptoms from Angel following this ingestion, correct?
I'd say immediate is a very broad term. It varies from person to person, different responses. We just don't know how, there's no uniform
All right,
time.
Just move on and ask, you actually, Angel accompanied Genesis to the hospital, is that right?
I believe that is correct, yes.
You didn't notice any symptoms with Angel that were consistent with pesticide poisoning, is that right?
No, I don't believe so, no.
All right, and you said that you have experience with homicide poisonings, is that right?
Well, that's some of the cases that can sometimes be sent my way.
Yes, and a homicide poisoning would be considered an intentional poisoning, is that right?
I guess if
Objection, Your Honor. Confusing the issues, may I be heard?
Yes.
Your Honor, what Dr. Kwan does face in the emergency room for intentional poisoning, that is not homicide, or that is homicide or murder, but today's case is civil battery. This is not to the extent of homicide or murder. This is not a criminal case, so this is still confusing the issues and misleading the jury to believe that this case is much more severe than it is.
May I respond, Your Honor?
Yes.
Intent is one of the aspects that the plaintiff has to prove today, and I believe that this is relevant to the case as the plaintiff has to prove the intentional poisoning.
May I respond to that, Your Honor?
Very quickly.
Your Honor, using the term homicide is misleading to the jury. That right there I would also add the objection of more prejudicial than probative. Today's case is civil battery. It is not homicide. It is not murder. These terminologies can confuse the witness, can confuse the jury, and misleads the jury to believe that the burden of the plaintiff is higher than it actually is. Therefore, it is still misleading the jury, and it is also more prejudicial than probative, Your Honor.
Defense counsel, can you please restate your question to me so that I can reevaluate?
Yes, I said homicide poisonings are considered intentional poisonings.
Okay. I will sustain the objection as to comparing any type of poisoning with homicide in the sense that it is a criminal matter. However, you can still ask him about intent behind any types of poisonings.
Motion to strike, Your Honor.
Yes, it's granted.
There was nothing that led you to believe that Genesis' poisoning case was intentional, right?
Sorry, can you repeat the question one more time?
Yes, there was nothing that led you to believe that Genesis's poisoning case was intentional, correct?
Objection, Your Honor. Proper legal opinion may be heard.
Yes.
Your Honor, the opposing counsel has asked about the intent. Intent is a legal terminology. Intent cannot be answered by a medical doctor who does not have knowledge in the legal realm. The doctor is not a lawyer. He is a doctor, so he can answer questions regarding medical terminology, but not intent because that is a legal term.
May I respond?
Defense counsel, if you can establish that he has any foundation to discuss intention, then he can answer. Otherwise, we'll need to move on.
Motion to strike, Your Honor.
Not right now.
Yes, Your Honor.
And Dr. Kwan, you mentioned that it's a possibility that Genesis consumed a contaminated food or drink. Is that correct?
Yes, either or could have been the case for today.
And this food or drink could have dissolved and combined with the wine in the stomach, correct?
Although that is a possibility, the wine was the only content that tested positive, not the food contents.
Yes, but during the digestive process, you can't actually draw that the wine itself contained the pesticide, correct?
Yeah, I mean, there's not enough digestion at the moment, so I can't clearly say, but I can say that it is a possibility, yes.
So you cannot definitively say that the pesticide came from the wine, is that right?
That is correct.
No further questions, Your Honor.
Your Honor, I do have a quick question to the prior objection about improper legal opinion. As no foundation has been laid, can we assume that testimony has been stricken?
Yes.
Thank you, Your Honor.
Thank you for following up on that.
Yes, Your Honor.
Do you have any further questions for this witness?
No further questions.
Your Honor, we do have a very brief redirect.
Okay.
Now, Dr. Kwan, on cross, you did mention that you mentioned pesticides being in the stomach. Could you elaborate a little bit more about that?
Right. So in regards to the testing that we did about the about the contents of the stomach of Mr. Petrillo, as I've stated earlier, there were two things. There was food contents and there was wine contents. Only the wine tested positive for the pesticides. The food content did not test positive. The food content tested negative for pesticides.
No further questions, Your Honor. We pass the witness.
Defense counsel, any further questions?
No, Your Honor.
All right, this witness is excused. Y'all, we can take a 5-minute break. You will need to be back at 3:55.
Yes, Your Honor.
Yes, Your Honor. And with that, the plaintiff rests our case in chief.
Okay. And just remember that this is still streaming while we're gone.
Yes, Your Honor.
Are we here?
Yes. Yes, Your Honor. The defense would like to call their first witness.
I just want to make sure everyone's back before we keep going. Are we ready to go? Plaintiff's counsel? Okay, great. Go ahead.
We'd like to call Austin Lewis to the stand.
I'm sorry, I can't hear anything. Did you call me?
Yes.
Hello,
Can you hear us?
I can hear you now. Yes, I'm sorry. I had to put in my earbuds.
No problem. All right, let's go.
Could you please introduce yourself to the court?
Yes, my name is Austin Lewis and I make wine for a living. I've really been around wine my whole life. Right now I work at Peony Estates, and before that it was at Danny Francasio's winery for 10 years with Harper Martini, actually.
Tell us about how Peony Estates began.
Well, in 2015, one day at work, Harper approached me and let me know that she was going to start her very own winery, and asked me to come along as the head winemaker. So the rest is history, I suppose. Personally, I didn't think it was the nicest place, but I trusted Harper, I guess, and I hate Danny, so I was ready to leave.
Tell us about your employment at Peony Estates.
Well, at Peony Estates, my main duties include oversight of the growing, harvesting, and bottling of the wine. But you know, a lot of other responsibilities tend to pop up in order to keep things running smoothly. You know, Harper oversees me or checks in sometimes, but I'd say she's more the face of Peony Estates.
Being in charge, what were Harper's responsibilities in the business?
Well, you know, Harper's the boss lady and handles a lot of the big picture things, she likes to say. You know, like the business side of things, whatever that really means. But, you know, she always seems to be busy with something because I'm the one handling the real issues.
What kinds of issues?
Well, the big one is that years ago when Harper was deciding to start this winery, she found the Salove Swamp and thought, oh, this is the perfect place to grow grapes for wine.
Objection, Your Honor, to speculation.
Response?
Do you want a response from me, Your Honor, or from opposing counsel?
Opposing counsel.
Sorry, what statement are you objecting to?
The statement in specifically that Harper thought that this would be the perfect place to form a vineyard. This would be, the witness would be going into the mindset of Harper Martini, and it would be speculation.
Yes, this isn't really that important of a point. I'm just trying to establish the witness's business partnership with Harper Martini and just kind of establish how they became to work together.
Okay, but that doesn't tell me why it's not speculation. Okay. The defense counsel, do you have any response to the speculation objection?
No, Your Honor.
Okay. Then we will strike the testimony.
Yes, Your Honor.
Can you explain what was done to resolve the issues with this pesticide problem?
Well, I of course tried organic methods at first, but Harper didn't really react well to the financial aspect of it. It was taking a financial toll on Peony Estates. So she decided that we would start using chemical pesticides instead. And so we would spray the foundations of all of our buildings as well as the grapevines.
Finances aside, what was your opinion of these changes?
Well, I wasn't really worried about spraying the buildings, spray everywhere. I really trust our employees with my whole heart, but I did fight strongly against the use of the pesticide on the physical grapevines because it would expose our grapes to unsafe levels of chemical pesticide. And of course, that's not safe for our customers. So, and especially because we have really poor drainage, we're on a slope. So I was just very concerned.
Could you explain how this would affect the grapes?
Yes, so the grapes that are at the bottom of our slope there's really bad drainage. So they're exposed to unacceptably high levels of pesticide. And I made this crystal clear to Harper, but she was insistent about continuing to use them. I guess eventually
Objection, Your Honor. Specifically to improper opinion regarding the witness's statement that the pesticides at the bottom of the vineyard would be at unacceptably high levels. The witness is not an expert in the toxic what the toxic amount of pesticides would be, and so this is an improper opinion, Your Honor.
I mean, she's already stated that more than once now, so I'm gonna have to let it keep going.
Yes, Your Honor.
Could you explain how this would affect the grapes?
Yes, so like I said, the grapes at the bottom would be exposed to high levels, and I told Harper, she was insistent, and I begged and pleaded that we did something because I didn't feel comfortable about it, and she ultimately let me dispose of any grapes I was concerned about.
You said that Harper let you throw out these possibly contaminated grapes?
Yes, I actually designed a system.
Objection, Your Honor, to leading question.
Okay. Sustained, you can rephrase.
Motion to strike, Your Honor.
Sure.
What did you do to combat this issue?
Well, I roped off all of the areas with poor drainage, and then in August for the harvest, I would dispose of any of the grapes within these areas.
How many grapes would you say get thrown out?
Unfortunately, we do throw out about a quarter of our production every year, and of course, Harper always tells me I throw out too many, but that's why I like to oversee it, because I know that what needs to be thrown out will. Unfortunately, I wasn't able to oversee this process in 2018 because I was out of town.
You were out of town for the 2018 harvest?
Yes, I was dealing with a family emergency, but I did leave very clear instructions to Harper to make sure that she would dispose of all of the grapes in the roped off areas, but I wasn't personally there, so I can't say for sure what actually ended up happening. I do know that Harper does typically disagree with the grapes that should be thrown out.
Objection, Your Honor.
You're gonna have to tell me what your objection is. Just saying objection's not gonna give me enough.
I apologize, Your Honor. Under Rule 403, inconsistent with the pleadings, Your Honor.
Inconsistent with the pleadings?
Yes, Your Honor. My apologies, Your Honor. May I present the pretrial order for battery, Your Honor?
Sure.
Your Honor, in this pretrial order for battery, both sides have been particularly admonished to refrain from using evidence that relates to a negligence claim, Your Honor. I believe that this specific line of questioning, at this point, Your Honor, going towards the possible negligent conduct by Peonia Estates is not relevant in today's case. This would be going towards a negligent claim, Your Honor, and considering this is a battery case, I believe it is that line of questioning is irrelevant.
May I respond?
What is section 12100?
Your Honor, section 12100 is the Midlands Code regarding proper storage and use of pesticides. And so I believe this line of questioning is going towards that code, Your Honor, and it's irrelevant in today's case.
Defense counsel, I haven't heard anything about the storage yet. So is that where you're going towards?
May I respond, Your Honor? In the bifurcation of that same document, any evidence relating or either side may still introduce evidence involving facts and circumstances of the relevant events as it is necessary to establish liability.
Response, Your Honor?
Yeah, briefly, claims counsel.
Your Honor, the section cited by section cited by opposing counsel regards to bifurcation, which is in regards to the damages. Your Honor, we're not talking about the damages here today.
Mm-hmm.
Secondly, Your Honor, the specifics line of questioning that the opposing counsel was going into is going into the potential misuse of the wine at the bottom of the vineyard, and this would be going towards a negligence argument, Your Honor, and this would not have any relevance towards battery claim.
Okay. Defense counsel, are you going into this section of this code?
No, Your Honor.
Okay. What is what do you presume that the witness is about to testify to?
We are just going to establish that Peonia Estates had a multitude of pest issues, which resulted in the use of pesticide that I believe is very relevant to today's case as we are trying to establish liability. And I believe that this is a circumstance of that.
May I respond, Your Honor?
Yes.
Your Honor, the opposing counsel is using the misuse of the pesticides in regards to the vineyard as an alternate theory in regards to how Genesis was poisoned, Your Honor. And this misuse of pesticides will be going towards a negligence argument about Peonia Estates being negligent, Your Honor. But the defendant...
Okay, well, counsel, I haven't heard anything about actually storage of pesticides or anything like that at this point in time. So I'm going to let you re-urge your objection if we get to that. But that's all of the pleading established that was not permitted to be going into was the storage issue. And so I'm not comfortable making a decision on that unless or until I hear that kind of testimony, and then I will allow you to re-urge your objection, okay?
Yes, Your Honor.
Did everything run smoothly with the 2018 harvest?
You know, I really can't say for sure because I was out of town and our harvest numbers do vary every year, so I wouldn't be able to tell based on the numbers if extra or if any grapes had been added to the harvest.
Were there any further pest problems?
Unfortunately, yes. There was an infestation in the bottling area in the wine cave, and
Objection, Your Honor, to my previous objection regarding improper pleadings. They're going into the storage area at this point, Your Honor, and going into the specific practices of what occurred.
May I respond, Your Honor?
Yeah.
He was just talking about the wine cave and the bottling area and how it became infested, and we did not. And this is general maintenance under the same section 12100 code. And she didn't mention anything about pesticide storage. We just talked about that the wine cave and the bottling area became infested.
May I respond, Your Honor?
Yes.
Your Honor, the code doesn't just deal with just the storage of pesticides. It also deals with how pesticides are used not only in the vineyards, but also in the interior spaces. And considering how the witness is talking about how pesticides were being used inside of the storage area, the bottling area, Your Honor, I believe this would be directly going towards this specific section in Midland's code. And so
Okay,
this would
can
be
you bring up the pleading again, please?
the pretrial order, Your Honor?
Yes.
Yes, Your Honor. I believe we will be bringing that up. The use and storage of pesticides, Your Honor. If you look at the line, plaintiffs may not enter any evidence or testimony relating to Peony Estates' use and or storage of pesticides for the purpose of demonstrating that Peony Estates failed to comply with Section 12100, Your Honor. So this would be going towards the use of pesticides.
May I respond, Your Honor? This only applies to the plaintiff.
Yeah, it does. So we're gonna keep going. Your objection is overruled.
Yes, Your Honor. Were there any more pest problems?
I apologize, Your Honor, for speaking, but is there a technical problem ongoing?
It looks like it. I'm waiting to see. Miss Austin, are you?
I am so sorry.
Okay. No,
I'm
you're
so
fine.
sorry.
Okay, let's keep going.
Were there any more pest problems?
Yes. Unfortunately, we did have an infestation in our wine cave and our bottling area. About a month before our harvest, I sent out a memo to all of our employees, letting them know that we would be spraying pesticide everywhere, effective immediately.
To clarify, you were the one to create this document?
Yes, I was the one to create this document, and I send memos very often, monthly, if not more. And, you know, communication is a really important part of running a successful business.
I'd like to bring up Exhibit 12, which is one of these memos. Would you recognize a copy of this document if I showed it to you?
Yes, I would.
Is this a fair and accurate copy to your knowledge?
Yes.
Has it been altered in any way?
No, not that I can tell.
Your Honor, the defense moves to enter Exhibit 12 into evidence.
Any objections?
Yes, Your Honor, to hearsay.
Yes,
You're
Your
gonna
Honor.
have to give me more than that.
Your Honor, these are out of court statements being offered for the truth of the matter asserted, Your Honor.
Okay.
May I respond?
Yes.
This is under Rule 803.6, this is a record of regularly conducted activity, and this is considered an exception to the hearsay rule. We have just laid the foundation of how these memos sent out by Austin was a regularly conducted business activity, and therefore is an exception to hearsay.
Plaintiff's counsel, do you disagree that the proper foundation was laid for hearsay?
I do disagree, Your Honor. Under Rule 803.6, Your Honor, if we look at Section D, we did not have any foundation in regards to the proper certification of this document. And so, Your Honor, I don't believe that this exception applies, Your Honor.
I'm sorry, to the proper, I missed what your complaint is with the foundation.
Yes, Your Honor. 803.6, Section D, Your Honor.
Okay. Okay. If that's your only reason why foundation has not been met, then I will overrule your objection.
If you could, Austin, could you just read the first sentence of the second paragraph out loud for us?
We need each and every one of you to prepare the entirety of Peony Estates for an imminent pesticide spraying.
Could you continue?
We need to do this quickly and cheaply. Nothing else matters. We're operating on razor-thin margins, so every little bit helps. If we don't get the spraying done by the end of the month, we will have
Objection,
no...
Your Honor, to cumulative. I believe since this exhibit is already entered into evidence, I believe the witness reading the entirety of the exhibit into the record is cumulative.
Overruled.
Yes, Your Honor.
Can you tell us about the inspections that took place at Peony Estates?
Yes. There were frequent inspections. Unfortunately, we did receive some citations, even though I made extensive efforts to train our employees. We were cited a few times for improper pesticide use and storage, and that our pesticide was stored too close to the bottling areas. So we actually received one month before Casey and Genesis's wedding, and I wanted to retrain employees, and Harper told me I couldn't. Said it wasn't a big deal.
Did anything? Sorry. Did anything else happen before the wedding?
Well, we wanted to make sure that there wouldn't be any bug up here at Genesis and Casey's wedding, so we sprayed everywhere. We did have a little bit of pesticide, or we had a few full bottles actually of pesticide left, so we threw those away in the dumpster to make sure they weren't out. And the Carol wine bottle was also thrown away in that dumpster and found later tested positive for contamination.
No further questions at this time.
May I proceed, Your Honor?
Please.
Miss Lewis, you personally know Harper Martini, correct?
Yes, I've worked with her for about 15 years.
You also personally know Genesis Petrillo.
Yes, less well.
You also happen to see the relationship between Harper and Genesis, correct?
Yes.
And based off your observations, that relationship was contentious, correct?
It was a little tense, yeah.
In fact, Miss Lewis, Harper told you that she hated Genesis, correct?
Yes.
Harper even told you that if she could push a button and make Genesis disappear, she would do it, right?
She did.
Harper wanted the wedding canceled, correct?
Yes.
Now moving on, Miss Lewis, you personally know that Harper is familiar with the use of pesticides, correct?
Yes.
Your Honor,
She should be.
Response,
I
Your Honor?
didn't hear your objection. I'm sorry.
I objected to speculation. The witness cannot testify to whether or not Harper knew about this.
Okay. Response, plaintiff's counsel.
Yes, Your Honor. I specifically asked about her personal knowledge. I wasn't asking her to speculate as to what Harper knew. I was specifically asking for her personal knowledge, Your Honor.
Okay, overruled.
Yes, Your Honor.
Miss Lewis, you personally know, to your personal knowledge, Harper knew about the use of pesticides, correct?
Yeah, she should.
To your knowledge, Harper knew where the pesticides were stored, correct?
Mm-hmm.
Now, in late 2018, an employee got sick, correct?
Yes.
And that employee got sick of pesticide poisoning, correct?
Yes, it was very scary.
In fact, that employee almost died. Isn't that right?
Yes. It was terrifying.
Now, Miss Lewis, Harper told you she knew about this incident, correct?
Mm-hmm. Yeah.
And in this incident, a glass of wine was contaminated by pesticides, correct?
Mm-hmm.
And the employee drank that glass of wine, correct?
Yes.
Miss Lewis, Harper told you that she knew that pesticides in wine were odorless, correct?
Mm-hmm.
Miss
Is that
Lewis, please answer verbally.
Oh, I'm so sorry. Yes, she did.
Harper also told you that she knew that pesticides could not be seen in wine, correct?
Yes.
Harper told you that she knew that pesticides could be poisonous. Isn't that right?
Yes.
Harper also told you that she knew that pesticides could be fatal.
I'm sorry. I thought I heard an objection, but I might be wrong.
Yes,
Yeah.
objection, Your Honor, needlessly cumulative.
To what?
He kept asking statement after statement about the same question.
I feel like the questions were different enough. We'll overrule that.
Yes, Your
Miss Lewis, Harper told you that she knew that pesticides could be poisonous, correct?
Yes.
Harper also told you that she knew that pesticides could be fatal, correct?
Yes.
Now moving on, let's talk about you, Miss Lewis. You are an employee of Harper Martini, correct?
Yes.
And in fact, you have a 10% stake in Peonia Estates, correct?
Mm-hmm. Yes, I do.
You know that Harper Martini is on trial here today, correct?
May I be heard?
I'm sorry, did you object?
I don't know, Your Honor. I didn't hear anything.
Defense counsel, did you object?
Yes. To relevance, may I be heard?
Quickly.
I don't see. I apologize, Your Honor. I redact my objection.
Okay,
May I proceed, Your Honor?
please.
Miss Lewis, you have a 10% stake in Peonia Estates, correct?
I do.
And you are an employee of Harper Martini, correct?
Yes.
And you know that Harper Martini is on trial here today, correct?
Yes, I do.
And you are aware that it's possible that Harper Martini could lose this case.
Yes. I feel it at work.
Miss Lewis, you believe that if Harper Martini loses this case, the business is going away, correct?
It would be hard to come back from it.
And you would lose a lot of money if that happened, correct?
Probably so.
Now, I want to talk to you about something you stated in direct examination. You said that approximately a quarter of your grapes were thrown out during a harvest, correct?
Yes, that's what was necessary, but it was unfortunate.
Right, and you'd agree with me that a quarter is a roughly 25%, correct?
Yes.
Now, you would recognize a copy of your affidavit if I showed it to you, correct?
Yes.
Your Honor, permission to approach the witness and opposing counsel in turn before it has been marked as the witness's affidavit.
You may.
Ms. Lewis, this is your affidavit, correct?
Yes.
And at the bottom, it states that this is your signature, correct?
Yes.
And this is authentic?
Yes.
As you stated that roughly 25% of the wines were thrown out, correct?
I believe I stated that roughly a quarter, give or take, was thrown out. That can range. Like I said, our numbers aren't consistent and every year is a little different.
So is it your testimony here in court today that 25% of the grapes were thrown out?
No, it is not my testimony because it can range. It usually ranges around 20% to 25%. Sometimes, like I said, a quarter, kind of like roughly. I don't know.
Objection, Your Honor. Improper impeachment. May I be heard?
Yes.
This, again, like my witness just stated, this was just a rough estimate, not specific, as this was a yearly practice at Peony Estates, and this was not directly, and this did not directly contradict her affidavit.
May I respond, Your Honor?
Yes.
I specifically gave the witness an opportunity to correct her statement. I asked, did you state that the quarter of the harvest was thrown out? She said yes. I asked if that would mean 25% of the harvest was thrown out. She said yes. Your Honor, I believe that the witness had plenty of time to correct herself. I'm simply going towards what she stated in her affidavit and the inconsistency with what she stated here today.
May I
Okay.
respond?
No, overruled.
So, looking at line 101, it states this resulted in throwing away about 20% of our production each year. Isn't that right?
Yes.
All right. Your Honor, I have no further questions. I ask that the affidavit be brought down.
Okay. Defense counsel, any further questions for this witness?
No further questions. We pass the witness.
Great. Witness may step down. Defense counsel, we may call the next witness.
The defense calls Danny Francasio to the stand.
You may proceed.
Good morning, Ms. Francasio. Can you please introduce yourself for the court?
Yes, hi, my name is Danny Francasio, and I own and operate Rosie and Pedro.
And what is Rosie and Pedro?
Rosie and Pedro is a winery named after 2 rescue dogs.
And what exactly is your relation to today's case specifically?
So Harper worked in Rosie and Pedro as a cellar hand for 3 years, from 2012 to 2015. So we have quite a bit of a history right there.
And what was her job while y'all worked together?
So Harper basically took care of the fermentation process and keeping the wine away from the pesticides and informing me if there was any pests near the wine.
Now, you mentioned that she monitored the pests to inform you if there was any present. Did she ever work with the pesticides directly while her time at Rosie and Pedro?
No. She never did. All she had to do is just inform me and we take care of it.
And how often did you spray for pests over the duration that Harper was working there?
Like 5 or 6 times.
Did Harper ever perform any of these pesticide treatments?
No, again, she does not have to do any of that. She just informs us and we do all the process.
And where do you store your pesticides?
We store the pesticides really far away from the wine because we do not want it to contaminate the wine and possibly poisoning someone.
Is it common to store them this far away?
Oh yeah, this is not just common, this is like the law. So you have to do that.
So are pesticides something that you see in your winery on a daily basis?
Yeah.
Would it be common to see pesticides in the kitchen?
No.
So would you believe it to be dangerous if there were pesticides in the kitchen?
Yes, it's very dangerous because
Objection, Your Honor. Confusing the issues. May I be heard?
Yes.
Your Honor, the witness is currently testifying to whether or not it is dangerous to keep pesticides in a kitchen. This goes directly to Midlands Building Code 12-100, which discusses the usage and the storage of pesticides. This witness is trying to provide the alternate theory. As co-counsel has raised before, it is confusing the issues in the battery pretrial. Parties are admonished to
plaintiff's counsel, I'm going to tell you that I've already ruled on this issue, and the order specifically states that plaintiff cannot do this. It does not state that defendant cannot do this, and so we will refrain from making objections that I've already ruled on.
I'm sorry, Your Honor. My sound had cut out, so I couldn't hear that part. I did not know you made a prior ruling. But Your Honor, I would like to amend my objection to improper opinion.
Okay.
Response, Your Honor.
In what way?
The witness is currently testifying to how pesticides are dangerous. The witness does not have any medical knowledge. She does not have any history. So therefore, she cannot testify to whether or not pesticides are dangerous.
Response, Your Honor.
Yes.
My witness has already stated that she worked at a winery where she consistently used pesticides and performed treatments. Therefore, I would hope that she would be aware of the risk, as she was aware of the risk of how to handle and store pesticides because she was a user of pesticides in her daily business.
Okay, can
Your
we
Honor.
lay the foundation for her knowledge of the risk of using pesticides, and then we can keep going?
Yes, Your
Your
Honor.
Honor.
So were pesticides something that you would use commonly at your business?
No.
Did you ever perform pesticide treatments?
Yes, I performed multiple pesticide treatments around 5 or 6 times.
And when you performed these treatments, were you aware of the risk that they posed?
Yes, obviously, because this is what you get when you get your license. You need to learn this stuff. You need to keep the wine away from the pesticides.
So would you believe it to be dangerous if pesticides were in the kitchen?
Yes, absolutely.
Your Honor, objection, Your Honor, to improper opinion may be heard.
Yes.
Your Honor, the foundation that opposing counsel has laid the witness has testified that it is not a common practice that the witness has done. Therefore, the witness does not have sufficient knowledge to be able to determine whether or not pesticides would be dangerous.
Response, Your Honor.
Yes.
I do believe I laid the foundation that my witness has experience using these pesticides and using these pesticides safely at her winery and performing these treatments. While they might not have been a daily basis, she still had to perform them 5 to 6 times, and she legally would have to have training and knowledge that these are dangerous because she has to own a winery and have that certificate and have that training.
Have you laid the foundation for that certificate and that training?
No, Your Honor.
Please do so.
Ms. Francasio, how did you come to work into the winery business?
Okay, so basically, I found my winery. I've been very interested in grapes and wine since I was a little kid. And I bought this land from this guy named Paul. And basically, after that, I owned this winery, and I had 2 rescue dogs because Paul owned these dogs. And to own a winery, you need a liquor license because you're making wine. And you need to go through a process that teach you to take care of the pests. And so they teach you how to work with pesticides and such. And as I mentioned before, I have done this process 5 or 6 times. So I have experience with that.
And Ms. Francasio, did you attend school to help you with your training and going into the wine industry?
Oh, yes, I did. I have a BS in biology and fermentation, and the fermentation of fruit. And then I took an MBA from Duke to just see how I can turn the art of turning profit.
And are you aware of the laws surrounding pesticide usage and proper pesticide usage?
Yes, obviously.
All right, so would you agree that pesticides are dangerous to be seen in a kitchen?
Objection, Your Honor. I re-raise my objection to improper opinion. May I be heard?
Yes.
Your Honor, 702, pursuant to Rule 702, a formal certification is not permitted for experts. The witness, just because she does have a certification, it is not permitted that she is an expert, and an interest does not mean that she has knowledge or expertise. Therefore, she cannot testify to whether or not pesticides are dangerous just because she has an interest and just because she has certification.
Response, Your Honor.
I'm sorry, plaintiff's counsel. I don't think that's what that rule means by certification. Can you pull it back up, please?
Yes, Your Honor.
Right. Okay. So, plaintiff's counsel, I don't know if you know this, but before probably your time, you used to have to formally certify witnesses, and that's what as experts. So you'd have to actually tender the witness as an expert in these competitions, and that's what that is referring to.
Yes, Your Honor. However, I would still raise my objection to improper opinion because the witness still does not have the specialized knowledge in order to testify to whether or not pesticides are dangerous. They have not laid enough foundation to complete the prongs of 702 if that's what the opposing counsel is wanting to do.
Response, Your Honor.
Yes.
We are not here to make my witness an expert witness. We're not asking her specific scientific facts about pesticides. We are simply asking her based on her personal knowledge as someone who worked at a winery and coming with winery as any agriculture business using pesticides, how she perceived the risks and the dangers of pesticides that are clearly stated on a label, you learn about in school, etc. We are not establishing her in any way as an expert witness.
Response to that, Your Honor.
Very, very quickly.
Your Honor, the opposing counsel has responded and said that the witness would know about the effects of pesticides. However, the witness, again, does not have the medical knowledge to establish that these pesticides will affect the body in these ways. How it will affect it or why it will affect it, the witness does not have that knowledge. Therefore, the witness cannot testify to that.
Okay, so far the witness has not gotten into any testimony regarding how it would affect the body. The question is simply if the use of pesticides is dangerous. And so I'm going to allow this testimony. You can re-urge your objection if the witness starts talking about anything that might be out of the scope of a lay witness's knowledge based on how it affects the body.
Yes, Your Honor.
So, Ms. Francasio, do you believe that pesticides in the kitchen would be dangerous?
Yes, it is extremely dangerous.
All right, so let's go ahead and move on. What year did Harper stop working for you?
2015, Harper tipped on me and decided to start a winery called Peony Estates.
And did you ever hear from Harper after she left your place of employment?
Yeah, man, she emailed me again in 2016. I did not respond to that email. She emailed me complaining about some pest problem. And honestly, I did not care. I did not want to hear from her again.
Was this the last time you heard from her when she was complaining about the pest problem?
No. So she emailed me again. And this time, though, I was really concerned because the tone was really serious. I felt like there was some actual problems. And she was complaining again about the pest problems. And so...
Objection, Your Honor, to speculation. Your Honor, the witness has just testified that there are problems and they never specified what problems. And also, I would like to add an objection of facts not in evidence. The witness is going on to discuss emails that were discussed between this witness in turn and the defendant. Those emails have not been entered into evidence, so she cannot discuss upon them.
Response, Your Honor.
Hold on really quick. The emails thing has long passed. She's already talked about them, so we're not going to talk about those. But you can respond to the first objection.
Which was speculation, right?
Yes.
I'm simply asking my witness, based off of this conversation that she had with Parker Martini, her opinions on it. I did not ask her to delve into the mindset of anyone else but her own. It was simply her testimony was based off of the information that she had received.
Okay, as long as the testimony is limited to this witness's knowledge and understanding and observation, then we can move forward.
Yes, Your Honor. Now, in the second email, did you end up responding?
Yes, I was really concerned. I even forwarded that email to an investigator because Harper was complaining to me about a pest problem that she had in her winery.
And why was this so concerning to you?
Because I was like, how did she forget all the process that I've taught her about keeping away the pesticides away from the wine and to do the treatments and all of that? And she completely forgot about it. And that was really concerning because I was like, what else could she have done wrong? And I was just worried about other people getting hurt because at the end of the day, she does own a winery.
And you said that this led you to contact an investigator. Did you ever hear back from the investigator?
Okay, so I didn't hear back from her for like the first couple of years because I thought she just thanked me for the tip, right? And then I thought it was all good. But then a couple of years later, she contacted me and told me that they had been investigating and, snooping around and stuff.
Objection, Your Honor, to relevance. May I be heard?
Very quickly.
Your Honor, the witness's testimony about the investigative journalist and what the investigative journalist has done makes no fact in today's case more or less probable. Therefore, it is irrelevant to today's case.
Defense counsel, very quickly respond.
If I could just remind you that the bar for relevance is extremely low, and we're not even really using the fact that she contacted the investigator, if I may proffer, for anything else but simply subsequent action to lead up and develop her testimony.
All right, let's keep going, then it's overruled.
Yes, Your Honor.
So did you ever hear back from the investigator?
Yes, so as I said, I did hear back from her a couple years later, and she was just telling me that she was snooping around and investigating, and apparently there's been some pest problems around and health problems, and she asked me if I had any comments, and I didn't, so that's what I told her.
Why didn't you want to comment?
I just didn't have any more information. I didn't know anything else, and I didn't want to add anything on it.
Did you ever hear back from Harper?
Yes. So after that, let me just tell you, Harper after that, thought we were buddies again and was kept emailing me and stuff and was always complaining about pest problems and just pesticides in general.
So in this next email specifically from Harper Martini, the third email, what did she say?
So the third email, Harper was telling us, was telling me that she failed the health inspection and that she wanted some advice because the wedding was coming up and she was really stressed and she had a drainage problem. So I gave her some advice on a brand to use for the drainage problem. It was this Italian brand. You can only get that from Amazon. It was John's Plumbing. I don't even remember the name, but you can only get that from online, right? And you can only get that because it's an organic one, and you need an organic one because organic ones, they don't do any chemical reactions with pesticides, and so you don't cause any poisonous material.
Was there anything else that concerned you in this email?
Just the fact that I was how did she not know all of this? And she forgot all the process and all about that because I've taught her about all of this. But yeah.
Did she mention anything further in the email about pesticide storage?
Yes, she said that she had a problem with pesticide storage, and she said that she didn't know what to do with that. So I told her to keep the pesticides so far away from the wine. They're not even supposed to be rooms apart. They need to be far, far, far away. And I told her that I was very concerned because we've talked about this before multiple times.
Do you know if she ever took your advice?
I have no idea.
No further questions at this time.
Your Honor, may we begin with cross?
Please.
Ms. Francosio, have you ever been to Peony Estates?
No.
And you don't know the inner workings of Peony Estates, do you?
No.
And you don't know where things are located at Peony Estates, do you?
No, not really.
No, Ms. Francosio, moving on to the rehearsal dinner, you were not present at the rehearsal dinner, were you?
No, I was invited though, but I didn't go.
So you do not know what happened at the rehearsal dinner, do you?
No.
And you don't know what the victim ate?
No, but I know there was a pesticide problem.
But you don't know what the victim drank either?
No.
And you don't know the whereabouts of the defendant, do you?
No.
Objection, Your Honor, it's needlessly cumulative. I mean, she just testified she wasn't at the rehearsal dinner. She doesn't know anything about it. Therefore, the counsel is listing all things that she's not going to have knowledge of.
Overruled.
I'm sorry, Your Honor, you cut out. What was the ruling?
Overruled.
Yes, Your Honor. Ms. Francosio, let's take a step back to July of 2015. The victim was a regular at Rosie's and Pedro's, correct?
Yes. Why?
In fact, there was a day where the victim came in without Casey Soto, correct?
Yeah.
And the defendant walked in, didn't she?
Yeah.
And the defendant screamed at Genesis, didn't she?
Yeah.
The defendant said that her child was going away, didn't she?
Well, okay. Basically, Harper was talking about how Casey was traveling and studying abroad. That's why she said
Miss,
that.
so is that a yes to my question? The defendant said that her child is going away,
Yes, but she only said
and
that it could be
she,
studying abroad.
Ms. Francasio, I'm going to ask that you limit your responses to a yes or no, please. Ms. Francasio, she blamed that on the victim, didn't she?
Yeah.
And in fact, she said, if you even try to take away my Casey from me, it'll be the last thing you ever do. Did she not?
Yes, she did.
Now, in June of 2018, moving forward a little bit, the victim approached you on how to report health code violations, did she not?
Yes.
Now, moving on to the wedding planning, the defendant called you frequently, did she not?
Yeah.
And she called you to vent, didn't she?
Yeah, I mean, at the end of the day, we used to be friends.
Now, Ms. Francasio, yes or no, she called to vent specifically about the victim.
Yes. I think she was venting.
In fact, Ms. Francasio, she left you voicemails, didn't she?
Yes.
Would you recognize a copy of a transcript of those voicemails?
Yes, I would.
Your Honor, permission to screen share what has been previously marked as Exhibit 18A through E?
You may screen share, yes.
Ms. Francasio, what am I showing you?
1 second. You're showing me a transcript of a voicemail.
Now, let's move on. So, has this been, pardon me, is this a fair and accurate copy?
Yeah.
Has it been altered or changed in any way?
I don't think so, no.
At this time, plaintiff moves to move Exhibit 18A through E into evidence.
Any objection by defense counsel?
No objections at this time, Your Honor. I'll re-raise if I find it needed.
Okay, it is admitted.
Now, moving on to on Christmas Eve of 2018, Harper Martini, the defendant, mentioned wanting to make Genesis move away, did she not?
Yeah.
Now, moving on to January of 2019. The defendant said if they sold a Genesis pesticide, I'd probably give them $1 billion. Did she not?
She did say that.
Now, a couple months later, in May of 2019, you received another voicemail, did you not?
I did, yes.
And and the defendant said, I am beyond the breaking point. It's going to be me or Genesis, but not both of us. Correct?
Yeah, I think that was just the wedding stress though.
Ms. Francasio, I did not ask you to qualify. I just did she say that?
Yes, she did.
No further questions, Your Honor. We pass the witness.
Defense counsel, any more questions for this witness?
No redirect, Your Honor.
All right, this witness may step down.
Your Honor, before we get to our last witness, I would just like to make you aware that we are dangerously close to all loss. Do you have any recommendations on what you would like us to do?
It's up to you guys how y'all want to handle.
Opposing counsel, do you have any thoughts?
I think at this point we run the direct and cross, and we should not do a recess. If we are too close to all loss, then we will do abbreviated, maybe 3-minute closings or something like that.
Okay.
That works for me.
Let's go.
Alrighty.
Awesome. All right, we'll try and get through this. All right, good afternoon, Ms. Martini. Could you please introduce yourself to the court?
My name is Harper Martini.
Now, we've heard a lot about your winery today. Could you tell us a little bit more about Peony Estates?
I founded Peony Estates about 5 years ago. I put all my energy into it.
Now, how was your business leading up to June of 2019?
Things had been on a downhill trend. We had a big infestation, had to dump out a large amount of product. Our profits were slashed, and we were receiving some pretty bad press.
Now, how did you avoid worsening your reputation?
Kept a low profile, more training for employees, told them not to do anything dangerous or reckless, things like that. But after the incident in 2018, I wasn't sure if we could survive anything else.
What incident are you referring to?
About 2 years ago, one of my employees, Kirby Doolittle, he left a glass of wine out in an area where we had been spraying earlier. He barely took a sip and he started shaking and convulsing. It was disturbing. I had to call the paramedics immediately. It was a close call.
Now, we heard a lot about Genesis Petrillo today. Can you tell me a little bit about your relationship with Genesis?
Genesis and I never saw eye to eye. That's not a secret. I did find him to be disrespectful, selfish at times, even rude. And I didn't trust that he would look after Casey. So these concerns were not without reason or unwarranted.
So on June 7th of 2019, how did the rehearsal of the wedding go?
It went smoothly, thanks to our wedding coordinator, Blair.
And what did you do after this rehearsal?
I spoke with Sam about giving each of the guests a bottle of our Horizon Blend wine as party favors, and Genesis the Cara wine.
Why did you give Genesis a different bottle?
Well, I noticed that he favored that particular blend and the bottle was named by Casey. So I thought it would be a nice gesture to make amends at Casey's request.
Was this the only bottle of Cara that Peony Estates had ever produced?
No, we had an entire cask of wine, the largest one on site, with hundreds of gallons inside.
Now, how important was this product to your business?
It was our most recent and costly batch to produce, so a lot was riding on it being a success and selling well.
So let's go back to the rehearsal. When did the dinner begin?
7.
Okay, can you take us through some of the events of that night?
The caterers brought out dinner. Members of the wedding party gave a toast. Casey gave a great speech. Genesis gave a really touching speech. I gave a toast, 2 actually. One right after Casey and Genesis, and another as the party favors and the bottle of Cara was being handed out.
Where was Genesis at the time that you delivered the Cara wine?
At the main table next to Casey and the rest of the bridesmaids and groomsmen.
Now, how long after the dinner did you stay?
About 30 minutes.
And during those 30 minutes, did you see anyone drink from the bottle of Cara wine?
I did. It was meant for Genesis, but I figured several of them might like to try it. It was our new blend. And I was right. I saw Genesis and Casey pour several glasses of wine and pass them around. I know Genesis drank some. Some of his friends drank some, as well as Angel Rodriguez, one of Casey's friends.
Ms. Martini, would you ever do anything to jeopardize your business or your family?
Of course not. These allegations have brought me absolutely nothing good. I don't speak to Casey anymore. My business has gone under and it won't recover. How could this have benefited me? How could I have wanted this?
I have time.
Okay. Defense timekeeper has 30 seconds, but it's up to y'all.
Defense timekeeper, how much time do we have?
Oh, we're right at the end. The 30 seconds was 30 seconds ago.
Oh, okay, perfect. All right.
Your Honor, we're good with moving on.
Already crossed, Your Honor?
Yeah.
All right, Ms. Martini, let's cut to the chase. You saw Genesis as a threat to your business, didn't you?
Among other things, yes.
And in about May 2019, Genesis sent you a voicemail, didn't he?
He did, yes.
And you recognize that voicemail if I were to show it to you today in court?
Yes, I would.
Your Honor, permission to tender what's been pre-admitted as Exhibit 8?
Yes.
We'll go ahead and talk about it before it gets put on the screen, or while it's being put on the screen. Miss Martini, Genesis told you that he was going to Paris, right?
He did.
And he told you that he was taking your daughter with him?
That is correct.
He told you you were going to die alone in that sad winery, didn't he?
Yes, a bit melodramatic, but yes, he did.
And Miss Martini, your wish for your daughter was for her to run the Peony Estates one day, right?
It was a family business, so yes.
So after you received this memo, you wanted to cancel the wedding, didn't you?
Yes, I didn't approve of the wedding long before that memo, though.
And let's talk about something you did later that month. You sent Genesis a note, didn't you?
I did.
And you put it in an envelope?
Yes.
And you'd recognize that note if I were to show it to you today in court.
Yes, I would.
You're under permission to tender to opposing counsel and the witness in turn what's been pre-marked as Exhibit 24.
You may.
You recognize this, right?
I do.
You wrote this note?
I did.
Hasn't been changed or modified in any way?
No, it isn't.
Fair and accurate depiction of that note, isn't it?
Yes.
Your Honor, at this time, the plaintiff moves to enter Exhibit 24 into evidence.
Any objections?
No, Your Honor.
It is admitted.
A permission to publish?
Yes.
All right, now you told Genesis to take the enclosed $300,000 and leave Casey, didn't you?
Yes, I wrote that. However, I did not intend to give Genesis any of that money.
Ms. Martini, I didn't ask you about what you intended. You wrote that, right?
Yes.
And you also wrote that you have until June 7th to decide, didn't you?
Yes.
And on June 7th, Genesis put this note back in the envelope, didn't he?
He did.
He kept the check,
Yes.
and he threw the envelope back at you.
Yes.
Now, I'd like to talk about June 7th. You also, on that day, gave Genesis the car wine, didn't you?
I did.
And you had tried this car wine before you gave it to Genesis, didn't you?
Yes.
And after you tried it, you made one bottle of car wine, right?
The first bottle of the batch, yes.
Right, so just that one bottle, right?
Mm-hmm. Yes.
And Ms. Martini, when you tried it, you didn't get sick, did you?
No, I didn't.
So Ms. Martini, you gave Genesis this car wine that you tried, and you learned the next day that he died, didn't you?
I did.
And Ms. Martini, isn't it true that a part of you is relieved that Genesis is out of your life for good?
Out of my life, yes. Dead, not so much.
Ms. Martini, I didn't ask about dead. I asked about out of your life.
Well,
that's a yes to my
yes.
question, right?
Yes.
At this time, we pass the witness.
I don't think there's time for any further questions, so the witness may step down.
And if I may check with the timekeepers, what time is all at?
5:05. So you can have 3 minutes for closings for each side if y'all want, or 2 minutes, depending on how y'all want to do it.
We can do 3 minutes. If I have any time left over out of that 3, I'll just save it for rebuttal.
Okay.
If we have time for it.
Go.
Okay. Your Honor, opposing counsel, members of the jury, may it please the court. There was a plan to poison Petrillo. Members of the jury, June 8th was supposed to be the day that Genesis Petrillo would walk down that aisle, exchange his vows, say his I do's, and get married to Casey Soto. But members of the jury, we learned that didn't happen today. And that didn't happen because the night prior, the defendant took a canister of pesticide, went into the kitchen, evacuated the kitchen, and put the pesticides into the car wine, and then gave it to Genesis that night. So on the day of his wedding, he died of pesticide poisoning, and that's why we sued him for battery. And with battery, we had to prove 3 elements. We had to prove that the defendant committed an act of harmful or offensive contact. We had to prove that the defendant had the intent to harm due to that harmful or offensive contact, and we had to prove that the defendant or that the plaintiff suffered harm as a result. To prove that first point, you heard from the defendant herself that car of wine was fine on its own. She tried it, she didn't die. But when Genesis Petrillo tried that wine, he passed away. Members of the jury, the reason why that happened is because that night she put the pesticides in the wine bottle. And we know that because 2 witnesses at 2 different times both tell Miss Martini, the defendant, saying that the pesticides were for Genesis because he's such a pest. Then we proved intent then we proved intent as well. You heard that Miss Martini saw Genesis Petrillo as a threat to her business. And we showed today that Genesis Petrillo was going to take Casey and go out of the state. something that the defendant didn't want to happen. So how did she respond? She wrote a note to Genesis. She told him, leave, take this $300,000 or I'll take you out the picture the hard way. Genesis, instead of taking that money and leaving Casey, decided to throw that note back at Miss Martini. So Genesis Petrillo chose the hard way. So Miss Martini took him out the picture the hard way. Members of the jury, to prove our third element, we showed you today that Genesis Petrillo got sick. We didn't have to prove that Genesis died because of the pesticide poisoning. We had to prove that there was some harm. And that some harm was the pesticide poisoning, the sickness that he suffered through that day. Now, members of the jury, we had to prove this to you by a preponderance of the evidence. That simply means that we had to prove that it was more likely than not. Today's case is not any kind of law and order murder trial. We had to prove that the defendant just did any kind of harmful contact to prove battery. We didn't even have to prove that she died because of the harmful contact. We had to prove that there was some kind of harm suffered because of it. Members of the jury, we've met our burden. And we ask you to go back and deliberate, examine all the testimony, all the evidence you heard today, and go on the side of justice and find the defendant, Harper Martini, liable because she had a plan to poison Petrillo. Thank you.
Permission to proceed. The bigger picture. Ladies and gentlemen, at the beginning of today's trial, my co-counsel Casey told you about the bigger picture. And not only this, but she also mentioned the scales of justice. And I want you to remember those scales of justice as I go over the elements that the plaintiff had to meet today. And remember that this scale of justice does not begin even. That burden is solely on the plaintiff. Now, you just heard the plaintiff testify that they only have to prove 3 elements to battery. Well, this is not true. There are 6 elements that they must meet in order to prove battery. Now, for intent, I want you to really focus on the word prior here. Now, it was a prior intent for Harper Martini to put pesticides into the wine. But you heard today in court, and as it is stipulated in the facts of evidence, that the wine bottle was found in the same dumpster as the open container of pesticides. Further, plaintiff was not able to bring you any witness that could attest to Harper Martini ever intending to hurt Genesis in any way or intending to mix pesticides in the wine. However, you did hear how she was using pesticides to kill the pests in her winery, as every other winery does. Her intent for the pesticides was to be used on the pest, and she did. As to the second element, Martini acted to cause harm to Genesis, specifically through the poisoning as stipulated in element 4 as well. Not only did they not bring you any evidence of violent history, no evidence of her trying to hurt Genesis, they only manipulated their story to show you. You heard from Angel that Harper's own daughter was sitting at the table whenever Genesis offered to share the Cara bottle of wine after Harper's toast. Why, if it was Harper's intent to hurt Genesis via the bottle of wine, why would she allow her daughter in such a situation where she's being offered that wine with the pesticides? Because it wasn't her intent. Further, as to the 5th stipulation, you heard today that they didn't even mention what time of death that Genesis died. And they also brought their own doctor to testify to say that it was in their mouth and there was nothing, it could cause symptoms just by being in your mouth. But Angel didn't exhibit any of the same symptoms as Mr. Petrillo. Now, I want you to think of the bigger picture when you're deliberating today. Harper lost everything. It has no common sense. It goes against self-preservation for her to jeopardize everything she loved and cared about. And for that, you must find our defendant not liable for battery.
All right, scoring judges, let us know when you have your ballots in. I've let Elliot know that we're done.
Is there any way that the plaintiff witnesses could turn on their cameras for me? I'm trying to match names to faces. Thank you guys so much. I have all of the defense witnesses. I'm missing one plaintiff one. Okay, great. Okay, awesome. I am ready then. Thank you.
Perfect. I'm ready as well.
So y'all submitted, we're good.
Yes, yes.
I have to leave really quickly, so I am going to just give really general overall comments and then let y'all continue. I thought both sides did really great, especially with the technical issues and being separated from everyone. That's very weird for me to see. So I think that adjustment was really well done. I will say that there were a lot of hearsay objections that I felt like were missed, and instead other hearsay objections that were not as good were lodged. And so I would definitely both sides work on that. I understand that there are technical things that happen during these, and so Miss Kim, I'm very sorry for getting on to you about missing my prior ruling. So I'm used to being like that whenever we're in the room together, so I apologize for that. But I think but I think y'all did great, and I really appreciate y'all working so hard on this and doing it when y'all can't even be in the same room. So do y'all have any questions for me before I run out?
Thank you for judging.
Thank you
so much for judging. Yes.
Great. All right. Well, y'all have a great time, and good luck the rest of the time. Thanks.
All right, guys, I'm going to be very brief as well. I did submit individual comments, so you'll be able to read those. Keep in mind, everyone get it out of the way. Great job, everyone. But my comments aren't going to be focused on all the good things. Everyone knows that they do good. Everyone knows things like that. First of all, everyone needs to have more energy. There were very few people that I could tell that actually looked like they were excited to be here. And that's a really big problem when dealing with this new virtual format. It's really easy for a judge to get bored. It's really easy to get zoned out and to not follow along with what you're doing. So even doing things like just smiling or varying your tone of voice can go a long way whenever it comes to really keeping the judges engaged. Along with that, I didn't see a lot of use of demonstrative aids. One thing you really can take advantage of in this virtual format is using screen share. I don't know if you've seen any other tournaments or saw the senior tournament last year or watch any trial by combat or anything, but all of the good teams, all the top teams at least, they're using demos and screen share throughout the entirety of the case in chief. Openings, closings, crosses, directs, it's always happening. It's just one of those things that allows judges to pay attention easier, and really it's just interesting. I mean, even in real life, last round I judged, we had, a real prosecutor as the primary judge, and he was telling them how juries just love that stuff. And mock trial judges love it too, especially in this new format when it's a lot harder to pay attention. Like I said earlier about the energy, a lot of people were getting really monotone. And I'm gonna be honest, guys, it doesn't need to be said for me necessarily. I'm sure everyone could sense it. There was a lot of really messy stuff going on in this round. Particularly, and I'm not picking on any sides in particular. I'm talking about like 5 objections too many from some people. And with that, you got to pick your battles. The judge was just saying that you missed a lot of hearsay objections, but you also made a lot of hearsay objections that were just like wrong or at the wrong part. There were a lot of objections that were just things that weren't important at all. And you got to be able to read the judge. Whenever the judge overrules an objection, you can't make the same objection again. That's going to annoy them. And if your jury members are picking up on it, it's going to annoy them too. So you got to read the judge. And if they like sustaining a certain objection to a certain piece of testimony, feel free to, do that, make it better for your case. But if they keep overruling you on something over and over and over again, and it just keeps dragging on, you got to stop. You got to pick your battles and object whenever it's really important for your case. You want to keep something out. And usually I wouldn't say that. Usually it's nobody makes any objections at all. But this was an odd case where there were so many objections to things that either weren't necessarily important or we kept revisiting the same issue. And it got really drawn on. So you just got to tighten up a lot of the things. That also speaks to, sometimes in your direct, you just got to avoid writing objectionable content. I know obviously you can't avoid it all the time, and sometimes you get attorneys that make creative objections, and that's great, but you got to tighten up your directs to where it's not super objectionable all the time. Yeah, the next point I had was just about, I heard a lot of relevance objections. Generally, those are never going to get sustained. I saw one that was actually particularly effective in today's case, but that's a rare instance. I suggest not really making too many relevance objections. And then on the other side of that, if you receive a relevance objection, that's your opportunity as an attorney to explain your entire case theory. So you can punish an attorney whenever they make a relevance objection by literally stating to them that fact is super important for this case. It's going to be great. So that's about all I have. Of course, that was all negative stuff, but I understand this is a new format. I love mock trial too, so I'm really proud of everyone and glad you guys are doing this. So moving on to Elizabeth.
Right, cool. So nice to see you all. My name's Elizabeth. I am oh wait, first of all, I don't think Brandon asked, where are you guys from? Like what schools are y'all from?
Plaintiff is UT Dallas.
UT Dallas, okay, and defense?
Is Texas A&M University.
Okay. I am a Baylor mock trial alum, so I know all about the mock trial world and I've been there myself. I, like Brandon, have a couple of things. All of the stuff you guys all did fantastic. Obviously, all of the stuff I'm going to tell you now is negative, so please don't get discouraged. You guys all did great. I don't want to waste your time, telling you that you all were perfect and amazing. I'd rather give you stuff that you guys can work on and improve on and go to be better in the competitive season. Same thing goes for my written comments. Those are all tend to be towards the negative. Please don't think that I hated you. I didn't. I just wanted to make sure that I gave you actionable and focused critiques so that moving forward you guys can do a little better. Why is it so dark here actually? Hold on. Okay, there we go. Okay, so I want to first and foremost echo all of the things that Brandon said. I think he made some great points, especially about over objecting. And that's, I think, one of the first things that I want to talk to you guys about too, is that in this trial, we did a lot of things that didn't matter. We made objections that didn't matter. We impeached on things that didn't matter. We spent several minutes learning about information that didn't matter, right? So not necessarily everything in your witness's affidavit should be brought up today in court. It means that you as a witness and you as an attorney needs to be extraordinarily discerning in figuring out what the court needs to spend our time doing, right? So if I'm a witness and I come on the stand and I mention offhandedly that it's raining outside, well, that's not relevant. But do we really need to spend the next 5 minutes arguing over whether or not that's relevant, right? If we have information that matters so little that it literally doesn't matter that it doesn't matter, there's no point in making the objection because we'll just spend all of our time. I know you guys saw we had to cut off our closings because we were spending so much time with objection battles. We had to rush our very last witness because we were spending so much time with objection battles. And I think all of you, all of your attorney witness pairings need to go through your crosses, your directs with a fine-toothed, like X-Acto knife and cut out everything that doesn't matter. Make 2 to 3 points per witness. And if it is not out, like if you choose your 2 to 3 most important things that you're going to get out of this witness, and if it is not in those 2 to 3 things, I don't want to hear about it, right? I don't want to hear about it if it makes your witness look really good. I don't want to hear about it if it makes your witness look really bad or whatever it is that you're trying to do. You choose your 2 to 3 main points that you think that I need to know in order to make my ruling, and you stick to those, point blank, period, end of story, right? Crosses need to be really fast. You get in, you make your points, you leave, right? Same thing with directs. Build up your character, make them like a person and fun and likable. Then you tell your story and then you leave. Same thing goes for objections. Only object on the important stuff. If you think that this is absolutely damning to your case, object on it. If no one cares either way, then maybe don't, right? We want to make sure that we're very discerning with how we use our time and what we spend our energy working on. Okay. And then I have only one more point because, like I said, 2 to 3 points, then you got to leave. Last point is for all of my witnesses. Have some personality, right? And this, okay, let me say something for a second. I spend all day at work sitting down on Zoom meetings and watching people with no personality talk to me. I don't want to come home and watch people with no personality and talk to me while I'm trying to enjoy mock trial, right? I love mock trial. That's why I'm here. That's why I'm volunteering. And that's why I'm watching all of you. But at the end of the day, mock trial is a show, right? That's what we always heard in our program. If you want me to watch your show, be entertaining. That means jokes. That means accents. That means having stories to tell, right? Make me like your character. Direct is the time when you can build that character. I know I talked a little bit about making sure that you only have 2 to 3 points. One of those points on your direct has got to be making your witness likable, right? If I don't like your witness, I'm not going to pay as much attention to what they say. I'm not going to believe them when they tell me information. And I'm not going to be listening to them to learn the other points that I need to know, right? So making your witnesses likable, making them enjoyable to watch is one of the most important things you can do as a witness and as an attorney. So all of you witness attorney pairs need to sit down together and figure out some sort of character for your witness. It's not enough to just be sad, right? That's not a character. Sad is not a character. People get sad. Characters get sad. You have to have some sort of character trait in there as well. And we got really close with some of our witnesses, like the doctor loved the costume, fantastic. The chef loved the costume, fantastic. Commit to it, right? Be an actual character. You're not just a doctor, right? Tell me a story about how you relate this information to your students, right? I liked the analogy, lean more into that. If you're gonna be a professor expert, then be a professor expert and be a likable professor expert. Same thing with the chef, right? You get a lot of fun as a character witness, play that up. Use some of experiences, things like that.